Good morning, everyone. Thank you for joining us this morning. My name is Summer Chandler. I'm a visiting professor here at the Southern University Law Center, and we are so happy to have you here with us today. We're going to be talking today about various challenges that exist with respect to participation in government, both with voting, exercising your right to vote, but participating in other ways as well. And so just a little bit about logistics before I turn it over to the panelists. We're going to have a series of speakers and they're each going to talk on different topics. They'll talk for 20 to 25 minutes each, and then we'll carve out about 5 to 10 minutes at the end for questions. And my co-host, Mr. LeBlanc, and I will be fielding those questions in the question and answer box you should see on the Zoom platform. And so we'll try to get to as many questions as we can, but if we don't get to your question, we will make an effort to follow up with the speakers afterwards and ask those questions. Okay, so with that, I am pleased to introduce our first speaker. Our first speaker is Professor Katherine MacFarlane with the University of Idaho College of Law, and she's going to talk to us today about various challenges that people with disabilities face when trying to access their right to vote. Professor MacFarlane, I'll turn it over to you.
Thank you so much, Professor Chandler, and thank you for having me today. It's wonderful to join such a distinguished list of panelists and participants. I am always warmly welcomed by the Southern community. I can't get enough of Southern. I was at a conference in 2017, and if you invite me, I am always happy to come. So as Professor Chandler mentioned, I'm going to be talking about voting rights and even running for office and the obstacles faced by people with disabilities. I'll talk a little bit as well about how the pandemic, of course, has impacted people with disabilities and in particular their ability to vote. I'll also speak specifically to the barriers that individuals with disabilities face with respect to serving in office, something as simple as getting into a state capitol building, for example. And I'll conclude by sharing some thoughts about what we've learned this year with respect to access and how we might carry some of the lessons forward in a post-pandemic world in a way that actually makes our political spaces and public life more accessible. So before I get into some of the details surrounding what's happening just in this very week, right? Let's start with some definitions. So the definition of disability from the Americans with Disabilities Act provides that a disability is a physical or mental impairment that substantially limits one or more of the major life activities of an individual. So disability includes visual, speech, and hearing impairments, as well as conditions like cerebral palsy, diabetes, heart disease, and intellectual disabilities. What's a major life activity? Well, for purposes of the ADA, a major life activity includes walking, interacting with others, and working. Of course, COVID-19 has had an impact on people with disabilities, but also what's been really interesting to me is to see the way that it's impacted and increased the number of people who may identify as disabled. So what does that mean? Well, the ADA's definition of disability arguably includes those whose underlying health conditions render them at high risk for serious illness from COVID. So many people that never thought about themselves before as disabled are now disabled as a result of COVID for purposes of the Americans with Disabilities Act, which I'll refer to as the ADA. What's an example? Well, asthma is a disability based on the definition I just gave you, but it typically wasn't one that people suffering from asthma needed to ask for a work accommodation for. It wasn't the type of disability that required any kind of accommodation or help at a polling location. But now, of course, we know that asthma renders people at higher risk for serious illness from COVID, which means that at work, you might need a reasonable accommodation, for example, to work from home or to work remotely. And what does that mean for voting? Well, if you have asthma and are disabled under the ADA, maybe that means that you cannot vote in a way that requires you to stand in a line in an enclosed inside location, right? For a prolonged period of time. And everyone has seen the lines at polling places these days. We know that unfortunately the vote is placing people who are at high risk for serious illness in dangerous situations. So let's talk a little bit about what the experience for voting is like in this country for people with disabilities, even setting COVID-19 aside. So Title II of the ADA, which governs most of the practices that I'm talking to you about today, requires that people with disabilities are given the full and equal opportunity to vote. So when you think of polling places, that means that people who use wheelchairs or scooters or have difficulty walking or using stairs, or those who are blind or have vision loss, have to have a full and equal opportunity to vote. And that equal opportunity extends to things like voter registration and the ability to vote early as well. The Voting Rights Act of 1965 also has some protections for people with disabilities. So under the VRA, those who are blind are entitled to receive assistance from someone of their choosing when they vote. And of course, we're all familiar with the VRA's provisions that prohibit conditioning the right to vote on being able to read or write or having attained a particular level of education or passing some kind of test. But think about how, in the absence of that protection, if states were to institute tests like the ones I just listed, the severe impact on people with disabilities. So a colleague, Elizabeth Pendo, a professor at St. Louis University, writes in the space of health law and disability law. And she's described what it may be like for someone with a disability who enters an inaccessible polling place. So imagine using a wheelchair or a walker and not being able to enter a polling place, right? You can't even get in the door because there's no ramp. Maybe the doors are too narrow, they're hard to open, or there's no automatic opener, or maybe the pathway to the voting area is obstructed. And it's so hard to know that a place is inaccessible, right, before you get there. What else? What if you have a vision impairment or some hearing loss and you encounter a voting machine that doesn't work based on your particular disability? Or maybe there's a lack of access because poll workers are simply not trained to set up features or troubleshoot malfunctions, or simply to assist folks with disabilities. So let's talk a little bit about numbers. In 2016, at the time of the November 2016 election, 40% of US polling places were accessible, which means that 60% were not. Think about the impact on people with disabilities who wanted to vote that year. And it's a large voting block. 35.4 million people with disabilities are eligible to vote in the United States. I want to touch upon a couple of instances in which voting has involved a discussion of either the ADA or the rights of people with disabilities. So I suspect that the crowd here today is familiar with what happened in Georgia in 2018, that historic election. In Randolph County, a majority Black county, there was an attempt to close 7 of the 9 polling places ahead of the November election, claiming that the reason was that the polling places did not comply with the Americans with Disabilities Act. Now, at the outstart, I have to say, of course, that was an attempt at voter suppression aimed directly at Black communities. But also, the solution to inaccessible polling stations isn't to close them, it's to make them accessible. But the rhetoric employed demonized people with disabilities, right? It placed some blame and scapegoated them. So what about voting during the pandemic? Well, there's been a great deal of coverage about what's happening to people in nursing homes. Now, people are in nursing homes for a number of reasons, right? Sometimes it's a result of age, sometimes it's a result of a disability that simply isn't the kind that unfortunately allows someone to continue living in their own home. So nursing home residents have always faced challenges when it comes to voting, of course, before the pandemic. But if they were mobile or had access to transportation, they could vote in general, right? Or maybe their families could come in and help them vote by mail. And in some nursing homes, election officials actually conducted voting in the nursing homes themselves. Okay, so what's happening now in nursing homes? Well, the in-person voting, any kind of voting in the actual nursing home is not happening. people cannot come in, families can't visit their family members in nursing homes. So everything I just described with respect to people who live there is now on pause. What else? So we've all seen the tremendously long lines where people are standing in line for, last count, it was 11 hours to vote in Georgia. So the sight of brave Black Americans standing in line to vote generates a lot of emotions. For me, I'm grateful, I'm humbled, and I'm incredibly angry that anyone has to take 11 hours to vote. It's unacceptable. Now, add on top of that, what happens to someone who has a disability that makes it difficult to stand in those lines? Or what about if you just need a glass of water? You need to use the restroom. You have diabetes and you need to find a clean place to give yourself a shot of insulin. Those long lines, aside from just being unacceptable for anyone, are an illustration of the way voting remains inaccessible this year. So a case called Merrill versus People First of Alabama, the Supreme Court issued a stay just 2 days ago, right? Everything is so topical right now with respect to what we're all talking about today. So let me tell you a little bit about this case. Certain Alabama counties had decided this year to allow curbside voting so that individuals who were at high risk for COVID, instead of going into these dangerous polling places, could be able to hand their ballot to someone and vote that way, right? What happened next? Well, Alabama's Secretary of State banned these counties from being able to allow or to invite people to participate in curbside votings. A case was filed in the Northern District of Alabama. It was assigned to Judge Callan, and groups like People First of Alabama, who assist people with disabilities, and the NAACP sought an injunction on the ban on curbside voting. Judge Callan's order granting that injunction is a beautiful piece of legal writing. I want to find a way to teach it. It covers everything from standing issues to civil procedure. Because the parties were seeking equitable relief, the case was tried in front of a judge and not a jury. But what's the most important part about that order? The obstacles facing disabled voters are centered. It opens with the actual accounts and the stories of people with disabilities, which is not often how federal district court orders are written. On Wednesday night, after this decision made its way to the 11th Circuit, the Supreme Court granted a stay. In other words, the injunction on that ban is now no more, which means the ban on curbside voting stands, and people in Alabama will not be able to participate in curbside voting in the next few weeks. Justice Sotomayor, joined by Justice Breyer and Kagan, dissented. The jurisprudence of Justice Sotomayor and her dissents is something that I think we'll be talking about for years to come. And she pointed out that the CDC recommends that states should consider curbside voting, right? It's safe. And she also pointed out that racial minorities, particularly Black people, are more likely to suffer from underlying conditions that increase the risk from COVID. Again, banning curbside voting, it's very obvious what the point of that kind of ban is. And she also made a very important point about how absentee voting is not an adequate alternative for people with disabilities. To the extent that they want to vote in person, telling people to vote by absentee is an entirely different process, right? And the solution should be to find a way to allow people to drop their ballots off, even if they're disabled. Okay, so let's say that you're a person with a disability, you're frustrated by everything MacFarlane just talked about, and you want to run for office. So what does that look like? What does it mean practically for someone with disabilities? Well, just pause for a moment and think about even the language we use, right? We talk about running for office. And of course, you're not actually running, but you are hitting the pavement. Our tradition in this country is that, for example, you go door to door. We know that Alexandria Ocasio-Cortez wore a particular pair of shoes that she wore out while she was campaigning, right? So, and if you're not knocking on people's doors, maybe you're going to county fairs and eating local foods. In order for all of that to really work for people with disabilities, there has to be accessible transportation, and all of the spaces that I just described have to be accessible. And so to the extent that you use a wheelchair, and can you really knock on someone's door? You have to get really creative with respect to what campaigning looks like. Okay, so let's say that you do win. Now let's think about your workplace as someone who's holding elective office. And I'll pause and tell you a little bit about what happened at the Idaho State Capitol just in the last 5 years. So the state spent $120 million renovating the state capitol, but didn't make the state capitol ADA compliant. And the ADA and various federal laws are quite clear that if you renovate a building after 1992, unless certain exceptions apply, you have to make the part that you renovate accessible. And so I wanted to read to you what the lieutenant governor at the time told the press about the failure to make the Idaho State Capitol accessible, because it's rhetoric that we often hear in response to requests that public space become accessible to people with disabilities. So he said, again, this is the lieutenant governor of Idaho. My understanding is the Department of Justice showed up and they got their tape measures out and found some problems with the ramps. And the big expense is the ramps. We have handicap ramps, but they're off by 0.5%. Okay, so a few things there. First of all, we don't use the word handicap. The disability community is very clear. People with disabilities or disabled people. And also think about this discussion of just, oh, it's just being off by 1%. So the grade at which a ramp is set, the incline, right, really determines if you're in a wheelchair whether you can actually make it up that ramp. To the extent that the grade is off, that renders an entire building inaccessible to people with wheelchairs. But I think I wanted to share that statement because it's emblematic of some of the animosity that the desire to make space accessible often faces. Okay, so again, let's say that you are in public office. Hopefully you can get into your own workplace. Who are your role models? Well, think about Tammy Duckworth of Illinois, right? The senator from Illinois, a former New York governor, James Patterson, of course, Franklin Roosevelt. I would say that JFK was disabled by his back pain, and the disability community has talked quite a bit about Joe Biden and his stutter and the way that it's been really empowering to watch him accommodate and work through his stutter in real time. That said, society, at least American society, American culture, really categorizes and sorts through the kind of disability that we're more comfortable with. So veterans who are disabled, although we don't help them the way we should through the VA, are heroes, right? So when they run for public office and they're disabled as a result of military service, that's a kind of disability that society is a little bit more comfortable with, right? In fact, some of the earliest forms of social assistance for people with disabilities were those created for veterans of the Revolutionary War. Okay, but if you're not a veteran, there are still so many stereotypes to overcome, right? Disability is still seen as weakness, even if we know better. Even if we know that physical prowess has nothing to do with mental acuity, there's so many stereotypes to overcome. Although I will say Senator Tammy Duckworth is a big champion of the ADA. Whenever there are attempts to roll it back or to amend it, she speaks out and has been a very powerful advocate for people with disabilities. So let me end on a positive note. I want to talk about a little bit what the pandemic has perhaps shed some light on, some ways in which we've changed our lives that actually are helpful to people with disabilities and that we may want to carry forward to the extent we want to allow participation, full participation in public life. So, for example, all aspects of work don't need to be in person, right? So to the extent that virtual participation is normalized, that may make it easier for people with disabilities who face obstacles when it comes to transportation to have a job that they're entitled to have, rather than having to make choices about where they work based on what they can physically access. Telemedicine maybe seems far removed from the topic today, but people with disabilities who, again, have to travel to a medical appointment and travel back and sit in an office, all of you know how long it takes to take care of a medical appointment, right? No matter how routine. Telemedicine has revolutionized the amount of time people with disabilities have to spend dealing with healthcare. What does that mean? It gives them more time to participate in public life. Also, with respect to government work itself, what really needs to be in person, or what have we really just clung onto because of the performative aspect, right? Committee work, hearings about a Supreme Court nominee don't really need to be in person. And so I would argue that to the extent that we should study and think about how those particular changes actually help and render public life more accessible for people with disabilities, and we shouldn't abandon them when the pandemic ends. Finally, I'll just give a plug to the disability community and its presence on social media. The disability community is on fire on Twitter, on TikTok, which I think I've aged out of, but I encourage all of you who are familiar with TikTok to check out people like Imani Barbarin, Alice Wong, Rebecca Coakley, Matthew Cortland, Kia Brown. And of course, this makes sense, right? Social media allows for an accessible place in most aspects. It can level the playing field with respect to public participation. Thank you.
Thank you. Thank you so much for that wonderful presentation. It's so much to get our arms around. So I appreciate your summarizing that for us. So just time for a couple of questions. So when you talk about disabilities, as you described it, it really can be, very broad in terms of the types of things that it might cover. Is there a particular physical barrier or legislative barrier, maybe in terms of how the voting is permitted in a particular jurisdiction, that sticks out to you as maybe the one that could be most pernicious in terms of voter suppression? Is there one, if you had to highlight one as you see as might be particularly damaging in terms of voter suppression, particularly with respect to this current election?
So I think that actually curbside voting could have been so powerful and was a wonderful accommodation. Public spaces, despite the fact that the ADA is now 30 years old, are still physically inaccessible to people with disabilities. But I would also say anything that renders voting a time-consuming activity is the kind of thing that places a very heavy burden on people with disabilities. Time is a really valuable commodity if you have a disability, because in general, the way public space is structured, you have less of it. Think about where you have to park to have disabled parking space, and then the way that a ramp is often at the back of a building, and the amount of time you have to finding that space, finding the ramp, getting up the ramp, and then making your way to the front where polling is. Time is really precious. So those long lines are absolutely horrible. There should be, but the curbside voting would have resolved so much for people with disabilities, and I hope that it's something that we don't abandon in years ahead. And right. So again, I think here we sometimes don't always think about the impact or the benefits that people with disabilities derive from some of these, from things that make voting more convenient, but they have a tremendous impact on disabled folks.
Okay, just a reminder to attendees, be sure to just drop any questions that you have in the Q&A box there, and Mr. LeBlanc and I'll pick those up. Okay, so I think we have time for one other question. So would you have a recommendation, so for an ally, for somebody who views themselves as an ally, is there a recommendation that you would have, one or two, that, ways that allies can support folks with disabilities in terms of their trying to access their, either serving in representative government or just exercising their right to vote?
Sure. So there's a phrase in the disability community, nothing about us without us. So that means whenever there's some sort of planning, either about voting or any kind of, I'd say, public event, there needs to be someone with a disability that has a voice, that thinks about planning, that thinks about things like providing an ASL interpreter. when it comes to online events, what does the transcript look like? Is there someone that's transcribing in real time? And to the extent that there isn't someone with disabilities who can fill that role, every aspect of public life has to just keep in mind the fact that we need to provide accessible spaces. And, with respect to what happened in Idaho, there are checklists about how to make a building accessible, and someone just didn't think about it. And so then it becomes this extra burden, extra effort, this annoying thing that slows down a renovation, but it just has to happen. It has to happen at the beginning. And that can, I think, having someone with disabilities involved in planning is key, but also, again, identifying someone who is the go-to expert on making something accessible and doing it at the outset rather than waiting towards the end.
Thank you for that. Thank you so much. I'm now going to turn it over to Mr. LeBlanc. Mr. LeBlanc, if you just want to introduce yourself, and then I'll let you introduce the next panelist.
All righty. Thank you so much, Professor Chandler. Hi, how's everyone doing today? My name is Cedric LeBlanc, 3L here at Southern University Law Center. We're on a time basis, so I'll go ahead and jump right in. Good morning and welcome to the Voting Rights Paradox. Election integrity measures damage confidence in elections section of today's webinar. We want to thank you again for being here today with us. Without further delay, we will jump right in. You guys are in for a real treat today, as I would like to give a warm Southern University Law Center welcome to the esteemed Atiba Ellis. Mr. Ellis is a professor of law at Marquette University, and his research primarily focuses on voting rights. At this time, I'll turn it over to Professor Ellis.
Well, thank you, Mr. LeBlanc. Good morning, everyone. My name's Atiba Ellis, and I'm happy to be here with you today to talk about the voting rights paradox. And if you'll just give me a moment to finish my screen share, then we will get started. And this is always more complicated than one wants, because given Zoom, all right, here we go. Sorry about that delay. With no further ado, we will start the show. All right, the voting rights paradox, how election integrity measures damage confidence in elections. And let me start out by just giving a great thanks to Professor Chandler and to the Southern University Law Center for inviting me here. I got my first tenure track job at West Virginia University over a decade ago. And in fact, a decade ago this semester, I gave my first public talk as an associate professor without tenure at the Southern University Law Center. And the topic of the symposium then was, in essence, looking at Barack Obama's first presidential term a year later. And so I am excited to be back a decade later in this very different political landscape to talk about election law and voting rights. So Professor MacFarlane's excellent talk worked from a premise, and I want to build from that premise to help kind of connect the flow in terms of thinking about representation, and both in terms of the right to vote, in terms of participation in civic life, and all of these things. One of the things I heard from Professor MacFarlane's lecture was simply that, one, the right to vote should be accessible to all, which means we have to find the common denominator in terms of voting rights access. Because the more, in the second premise, and I hope you heard her when she said this part, right? The more incidental burdens that we place, particularly on the disabled, but I think it's true for all voters, the more barriers, the more difficult we make it, the less likely it is that people will vote. And I come from the point of view that in a democracy, that should not be the case, that we should basically give everyone the opportunity for the right to vote. The right to vote should be treated as universal, but everyone, in terms of both their ability and their identity and their economic status and their political status, people are situated in different ways and in different places. And so this consciousness about affirmatively asserting this need for a right to vote that is universal to all, and then working to remove those barriers is essential. Given that, this leads me to talking today about the voting rights paradox. Given this sort of seemingly basic premise of American democracy, that the right to vote should be accessible to all, it seems paradoxical that measures intended to bolster election integrity actually defeat confidence in the fact that we want to accomplish the basic democratic premise that all citizens should easily be able to access the right to vote. That idea is a contested notion, and it seems ironic that that is so. Now, I have an explanation for this, drawn on my current work. My argument to you today is that the scope of the franchise in the United States, the ability for people to vote, has always been tied to the politics of worthiness as a way of insulating suffrage from those deemed illegitimate, immoral, or too dangerous to the privileges of citizenship. This rationale has translated into the use of barriers deemed, quote, rational, unquote, for measuring worthiness, socioeconomic and status measures that target vulnerabilities in citizens on the margins. And so, this is where I come from in this regard, and actually, let me give you the second page to just sort of lay out my argument here. The barriers for measuring worthiness have translated into boundaries justified by election integrity, measures specifically intended to forestall voter fraud and bolster confidence in the voting process. As such, these measures, driven by the underlying ideology, that is, that politics of worthiness, are easily mistaken for exclusionary practices, thus undercutting their legitimacy. Or, to step back from the law professor speak for just a second, the problem is we have seen over the 21st century and the most recent iteration of using claims of needing to protect the ballot, the need to protect the election process from people who would be threats. The argument is being put affirmatively to us as recently as the recent presidential debates that there are people out there who would damage the integrity of the process, and therefore they must be excluded. And so rules such as voter identification laws, proof of citizenship laws, limiting, access to the ballot box have come up over the last 2 decades. And as we know from Professor MacFarlane's presentation, those effects are accentuated in the era of COVID, and particularly for the population that is differently abled than what we would stereotypically think as being able-bodied. Given that, it is important to sort of unpack the ideology behind that. And so I want to take the next few minutes to talk about this development of this voting rights paradox, that election integrity measures, ironically, seem to be more about excluding voters rather than including voters. So in this sense, and I want to kind of begin by talking about the sort of difference between the actual issues in our modern political process versus the perceived issues and the sort of mythology of voter fraud that has evolved. And then I'll talk about why these strict laws have evolved, considering the recent shift in litigation over the last decade. And then I want to drill down specifically about this voter fraud problem, a problem that itself, and not voter fraud in its existence, it rarely exists. The odds of someone committing voter fraud are just about on par as the odds of me getting struck by lightning sometime during my life. But this perception of voter fraud, in my work, I call it the meme of voter fraud, seems to become more pronounced. And then I'll end with a few reflections on how these problems become even more pronounced in the era of COVID. So, to the first point, had I 40 minutes rather than 20, I would start out by talking about the long history of this politics of worthiness that I referred to earlier, and talk about how citizenship has been formed around identity, that someone's status as a citizen or non-citizen played a role, but those issues weren't all that important at the time of the founding, but issues such as one's race, one's condition of servitude, one's gender, one's citizenship in the terms of whether one is a member of an indigenous tribe versus a European colonist, all of those identity politics played out over the history of the franchise. And this leads to my argument about this politics of worthiness. We've always been out to exclude people on the basis of identity. Certainly, these things were remedied to a certain extent by the Voting Rights Act of 1965 and its principal measures that make real the promise of the 15th Amendment, which in and of itself took 95 years to come to fruition. And during that time, we saw the politics of Jim Crow, poll taxes, literacy tests, as Professor MacFarlane referred to, and other measures meant to disenfranchise being at play. So if we jump forward to the 21st century, these issues play out under the guise of talking about election integrity. And to be clear, no one disputes the fact that elections need to have integrity, that they need to be reliable, that we need a definitive and credible election process. But the question then becomes, what fits under this notion of election integrity? The notion that we see argued is the prevention of fraud, right? And so the perceived issues such as voter impersonation and non-citizen voting get moved to the fore. And for my money, you can add voting by people with felony status gets listed under this column of perceived issues. But by focusing on that, we end up missing a number of the actual issues of actual fraud, vote buying, voter intimidation, which in and of itself has become pronounced or at least concerning in the era of COVID, double voting, ensuring that our registration process is accurate without being over-inclusive, and the security of elections, whether by domestic or foreign interference. Indeed, I mean, one of the challenges of being an election law scholar in this time is trying to keep up. Day after day after day, new issues come up, including yesterday. I read a news story about how foreign entities have hacked and gained access to emails in order to write emails to citizens to intimidate them from voting. And oftentimes this targeting is on the basis of race. We need only think back to the Mueller investigation in 2016. So this talk about election integrity and targeting voter fraud, and to be clear, these perceived issues are about targeting voters themselves who are deemed to be acting wrongfully. This kind of talk of voter fraud makes us miss the actual issues. Moreover, it makes us miss the major premise that election integrity is as much about security as it is about access, right? That all citizens ought to be able to participate within the political process, from the vote all the way to holding and carrying out office, right? The access issues get played down. Those get moved to the back of the agenda on this premise that security matters most, and security is synonymous with integrity. But as I'm arguing to you, that framing leads to incidental exclusion, and those communities who feel that exclusion would then see this process as, to use a word that is often mentioned these days, rigged. Now, as I mentioned earlier, there were controls around this, particularly when it comes to race, to use it as another example, right? There were controls around this. Section 2 of the Voting Rights Act gives a right of action regarding any abridgment or denial of the right to vote on the basis of race. But then Section 5 required that states with a history of voting discrimination be supervised in their election rules. Any change they make must not harm communities of color. This supervision existed through this process called pre-clearance. Every time the law had to change, that legal change, once ratified, had to then be approved or pre-cleared in the language of the statute by either the Department of Justice or a federal district court in Washington, D.C. This forestalled and changed a number of the problems that we faced in the United States until Shelby County v. Holder. In the Shelby County decision, the courts, in essence, rendered Section 5 moot by saying that the formula for calculating which states ought to be subject to pre-clearance was invalid, because, as Chief Justice John Roberts argued in that opinion, the South had changed and Section 5 had to meet this standard of equal dignity of the states, not of the voters, of the states. On that basis, Section 5 pre-clearance ended, and a number of states who were then covered under Section 5 then immediately went forth and changed their voting laws in order to make their laws more strict, or as I put it in my own work, they engaged in hyper-regulation of the right to participate. Now, I note North Carolina and Texas as sort of ground zero of this change post-Shelby, but obviously even in states where this was not the case, including where I currently reside and work, Wisconsin, this elevated right to vote and arguable minority voter suppression ended up taking place. The three cases I list here, McCrory, Abbott, and Walker, all revolve around voter identification laws. And certainly the Seventh Circuit upheld Wisconsin's law in Frank v. Walker, but in Beasley v. Abbott and NAACP versus McCrory, we had credible allegations that these laws were meant to explicitly discriminate on the basis of race. The Fifth Circuit did not find such evidence in Beasley, but the Fourth Circuit in McCrory did, saying that the North Carolina legislature targeted African-American voters with, quote, almost surgical precision. And so the voter ID is just the starting point of this issue. Let me talk a minute about voter fraud. And here I will show you a series of tweets where the greatest amplifier of the meme of voter fraud, Donald J. Trump, repeated again and again and again and again that his election, even though validated by the Electoral College, nonetheless saw him suffering a popular vote loss of nearly 3 million votes, but that all of this was attributable to voter fraud. And so, as you can see from these tweets, he wanted to investigate voter fraud. This led to him appointing the Pence-Kobach Commission, with Chris W. Kobach, who is probably the second greatest amplifier of the meme of voter fraud, leading the commission. This commission, in its consensus, was in essence to sort of back rationalize President Trump's arguments about voter fraud interfering with the election, with which I would suspect that had the commission endured, they would have recommended even stricter regulations on the right to vote. But the commission folded because its aims came across as uncredible to a number of Democratic-leaning states, and the Republican-leaning states, for the most part, thought that his use of data would have violated the law. Kobach's also notable here because he is a proponent of proof of citizenship laws that required that every voter, when registering, present documentary proof that they are a citizen of the United States through their birth certificate or through their passport or other documents from the government proving their citizenship. A court inquired about Kansas's laws, and ultimately Kobach lost in his suit brought by the ACLU, and the court there said too that this proof of citizenship law illegal voting was in essence an icicle, that it was not next to non-existent, and such illegal voting by undocumented citizens or undocumented non-citizens, I should say, was the result ultimately of administrative error rather than some grand conspiracy in order to damage the right to vote. Now, as I'm saying, this damages election integrity in the sense that these sorts of laws and their voter suppressive apparent motives make people less confident in elections rather than more, to the extent that at least by July 2019, according to the Brennan Center, we have over a third of the states in the United States engaging in litigation around these laws. But this was certainly before COVID. Now, I don't want to spend too much time here because Professor MacFarlane's already talked in depth about the consequences of COVID and the election, but let me just point out a couple of things. What I will point out to you, one, is that disinformation, as I've already alluded to, has become a constant in our elections, and I think it's getting amplified because of COVID. Two, the accommodations that we have been talking about in regards to COVID, I need not go into great detail about them because we've already heard about it, but I will simply add that there appears to be a pattern emerging that Republican appointed judges, particularly Trump appointed judges, have tended to use this doctrine known as the Purcell principle, which comes from a 2006 case called Purcell v. Gonzalez, to basically say we can't change the rules so close to the election. It's unclear how close that is, but all of the lower court litigation arguing for and usually granting accommodations has been pushed back against by the appellate courts and the Supreme Court in particular. And even the exception that we saw, the recent decision by the Supreme Court not to stay a Pennsylvania Supreme Court decision extending the deadline for absentee ballots by 3 days, would portend a win in the short term, but maybe a loss in the long term, in as much as I think that decision is reminiscent of Bush v. Gore. And the final thought I will throw out here is that felon disenfranchisement is revisited. I mean, it's clear that felon disenfranchisement is going towards extinction slowly, but I hope surely. But we can all remember what happened in Florida. Amendment 4 passed, abolishing permanent disenfranchisement in Florida, but then the Florida legislature passed a law, which was upheld by the 11th Circuit, to interpret Amendment 4 as requiring payment of fines and fees in order to have a person with felon status to have their vote restored. This in and of itself works a disenfranchisement akin to poll taxes, and I am on record as signing an amicus brief making that argument. But it says to me that the old cycles of pointing out status and pointing out identity are repeating themselves in regards to the right to vote. And so whether it's race or class or disability, this is where we are in terms of our voting rights. And ultimately, it endangers the legitimacy of our elections. Thank you.
All righty, thank you so much for that, Professor Ellis. Just want to say a quick reminder to everyone here today, if you do have any questions, there is a Q&A section at the bottom. You can drop those questions there. So Professor Ellis, you talked a bit about social media with Donald Trump and putting out different news and things of that nature. So in this new age of social media and kind of what they call fake news, it's kind of playing a significant role in voter turnout and things of that nature. So how do you think that it will affect voting turnouts in the future holistically? And what are some ways or solutions that we maybe can combat fake news on social media? Of that nature?
Well, before I get to the fake news point, let's talk about the upside of social media briefly. I mean, we have seen so many political campaigns mobilized through social media, not just partisan campaigns, not just electoral campaigns, but I'm thinking Black Lives Matter. Black Lives Matter started as a hashtag in social media, and it has deeply impacted our society today. We could spend a whole other half hour talking about that. So I think that's the upside. I think the downside is combating disinformation, right? That sort of spreading rumors. I can think of one in particular comes to mind. Remember when Roy Moore and Doug Jones went toe-to-toe in the Alabama special election of about 3 years ago? In the wake of Jones's win, certain operatives literally came onto Twitter and was saying, I'm just saying what I heard about Black voters being bussed in from Mississippi to vote for Jones. I mean, that kind of disinformation the solution to that is to directly oppose it. I took the length of writing a blog post basically saying that that was a lie and that that's, inappropriate for any kind of partisan operative to be talking about. I think in a way, the only way to fight a meme is with a counter meme, and that having that sort of attention to the fact that social media is where these debates are happening now is going to be essential for elections. I think the other thing, and I put up a slide with my Instagram, Twitter, and my personal website. I have a TED Talk that is all about the meme of voter fraud and combating disinformation about voting. And one of the things that I talk about is, first and foremost, we have to demand evidence, right? I think it needs to become a political bottom line that if you're just talking to be talking without proof, that ought to be shunned and made inappropriate. I mean, Twitter and Facebook have engaged in that by tagging certain of President Trump's tweets, for example, as not credible information around voting. And I think we need to see more of that, both from the platforms and from each other, in terms of making sure that we get correct and credible information about voting.
Right. Thank you for that. And I think that that's very important as well, as far as your point of making sure we have that evidence, just to be able to solidify on the back end and bring more confidence toward our voting audience. So thanks for that, Professor Ellis. At this time, I'm not sure. I think you have to stop sharing your screen.
Okay, I can do that.
All righty. So once again, thank you so much for that, Professor Ellis, excuse me. At this point, we're going to be moving on to our next section.
And thank you for the invitation. Have a good day.
You have a better one. All righty. So without any further ado, we will now transition into our next section of today's webinar. This next section is called A View from the Other Side of the Ballot Box, what participatory budgeting can teach us about voter participation and outcomes. Here we have Council Member Amir Farokhi. Mr. Farokhi represents District 2 in Atlanta, Georgia. Councilman Farokhi will be speaking with us today about a different perspective. So at this time, I'd like to turn it over to Mr. Farokhi.
Thank you, Mr. LeBlanc. It's good to be with you and to be with everyone else. And I want to extend a thanks to Professor Chandler for inviting me to be with all of you today. I hope it's been an invigorating and intellectually stimulating morning. I know this topic is top of mind, not only in this moment as we're nearing Election Day, but it's really been, I think, front and center for this country over the last decade and will continue to be until we figure out how to secure the vote for as many people as possible for what should be a basic fundamental right in our country. As was indicated by Mr. LeBlanc's opening, I sit on the City Council in Atlanta, and I represent 6 neighborhoods that really form the center city. To the extent you've ever been in Atlanta or you know Atlanta, I kind of represent the skyline of Midtown and downtown, and then a few neighborhoods to the east, and have been in office for about 3 years. And very quickly, I learned and realized, perhaps I should have known this before, that folks just don't trust government much. In fact, if you look at international surveys and data, trust in government in the U.S. is pretty low. It's about 33%. And you look at some of our peer countries, Canada next door, just to the north, 60+% of people trust government there. And in Switzerland, it's over 80%. And so we suffer from a deficit in trust with a lot of institutions, whether it's media, government, increasingly institutions that have always been trusted, like academia and nonprofits, are now also seeing a decrease in trust. And so I say that to say, since I've been in office, I spent a lot of time thinking about civic trust, how to engage more people to make them feel like what they feel and say matters in the scope of city government. And how do we rebuild some of that trust? And part of it's frankly just about delivering what people expect you to deliver, but it's also about getting people engaged in a way that they feel is meaningful. And so soon after I took office, I came across the concept program called participatory budgeting, which is what it sounds like. It means people get to decide how money is spent, public dollars are spent. It started in the late 80s in a city in Brazil called Porto Alegre, and spread pretty rapidly around Latin America and Europe, and into the US probably in the last decade or so. And I find it to be really invigorating and exciting. It's simply saying to folks, here are public dollars that you have contributed to through your tax dollars. And normally a city, or it could be any governmental agency, it could be a county, a state, it could be the national government. But normally the city, in my case, would decide how that money is spent, right? We allocate dollars every year between police and parks and transportation, a whole host of kind of core functions that a city has to execute. And so what participatory budgeting says is, well, some of that money should be determined, how that money should be spent should be determined by citizens and residents. So it doesn't require any extra dollars. You're not going out to raise money on top of the budget. You're simply taking part of the budget and saying to the public, you decide how this is spent. So we went down the rabbit hole and said, all right, who around the country is doing this? Who around the world is doing this? What are the outcomes? Why would you want to do something like this? It has tended to be embraced initially by, I think, left-leaning political parties in other parts of the world as a way to give people more power. But you find pretty quickly in government that all types of people, regardless of their political persuasion, want greater say in the outcomes that happen at a city hall, for example. So I said, all right, let's see if we can try this in Atlanta. The first thing I did was try and get it worked into our city budget, which found little support from my colleagues who thought it wasn't good. They didn't want to turn over that much money to the public to decide how to spend, because ultimately what you're saying is all these bureaucrats you may have within government, civil servants, that their expertise is actually second to the expertise of folks in the community. But I kind of kept my antenna up and came across about $1 million that was dedicated for transportation infrastructure improvements in a part of my district. And I said, instead of me deciding how to spend it, which was within my right, let's have a participatory budgeting program for that $1 million in our downtown. And so we launched a program called Downtown Decides, really to see what the benefits of this would be and if people would be excited about engaging. And frankly, the results blew us away. So the way we set it up was we had 6 months. And so the first month and a half was really asking people to submit ideas on how that money should be spent. And we got all types of ideas. We had about 115 to 120 ideas. And some of them were crazy. Some of them were really small, like, hey, I want a crosswalk repainted here, to we want to see drones allowed to deliver products in the city, which was outside the scope of this work. So it got set aside. To we want a new bike lane on the street, or we want more street lights on the street, whatever it may be. So we did a month and a half of idea collection, and we went out to college classes. We spent time outside of train stations and subway stops. We, put it up online. We went to neighborhood groups. We tried to cast a wide net as possible. We sat in the lobbies of office buildings downtown to generate interest in the program. And then once those ideas were collected, we turned around and sat down with the city and the Department of Transportation and said, okay, we have these 115 ideas. How much do these cost individually? Because we had $1 million and any project needed to be $1 million or less. And through that process, and I'm going to get to the voting bit in a second. I just want to kind of walk you through how we ended up where we ended up. Through all that, we narrowed the bucket to about 36 projects, because some of them were outside of the geographic footprint we were working in. Some of them were more expensive than $1 million. Some of them were frankly illegal. Some of them were outside the scope of what city government has purview of. For example, we don't run our public transit system. So ideas related to that, we couldn't execute or implement. So we had about 2 months of a vetting of those projects, and then we turned it open to vote. And this was right when the pandemic hit. So our original plans were to kind of go out in the community, have a lot of in-person voting, in addition to online voting. We had to go entirely to online voting. And for a period of about a month, we had open voting for these 36 projects. We promoted it online. We promoted it through our civic organizations and neighborhood organizations. And we had, 3,400, 3,500 people vote, which is pretty remarkable. And that was in a district of 15,000 people. Excuse me, 50,000 people. But what was interesting is when we looked around the world, we saw varying levels of efforts to get people to engage in participatory budgeting programs. And the ones that were most successful, we found, were as inclusive as possible. So for example, in some places, they would say you have to have an address in a certain footprint in order for you to be able to vote. And we got to check your ID and make sure that you actually live in this area and you should have a say in it. We took the opposite approach. We said, look, if you live downtown, if you work downtown, if you go to school downtown, if you just visit downtown once a year, frankly, you should be able to vote because you experience this space and you have ideas. So we said, come one, come all. And the only check we put on voting was when you voted online, you got a text that we didn't keep anyone's number. You had to input your cell phone number. You get a text that just verified it was an actual phone number. And then that phone number wasn't able to vote again. So to the extent we were worried about people voting more than once, they would have to have had multiple cell phones, and to do it in mass, to really stack the ballot box, as it were, was pretty difficult to do. And we had 3,400, 3,500 independent individual cell phone numbers. And when we looked around and we talked to folks around the world in the country who were doing these programs, they said, look, you can contort yourself every which way to try and make sure that only certain people are voting, but ultimately the outcomes are better the more people you invite to participate. And which may seem like a simple concept to you and I, but one of the things that you tend to run up against when you run a program like this is people will say, look, it's going to be the same 50 people who come to neighborhood meetings who are going to drive this process, or, people are going to have some sort of crazy idea. And if they have resources behind them and they can promote it, that's going to win. And the opposite is true. So we had some pretty far out ideas that were part of the process, but my understanding was the more people get to vote, people are pretty smart and judicious about it, and they're going to pick the ideas that work best in their lives. And sure enough, that's what happened. We had a couple projects that were backed by organizations and nonprofits that were pretty intense, or a little bit outside the scope of what folks wanted. And even though they promoted their project, they campaigned hard for their project, it didn't win. And the way we did voting, this is another way to, I think, a good lesson from all this. The way we did voting was we didn't say you can only pick 1 or 2 or 3 of these projects. We called it shopping cart voting. So when you logged on online, you had $1 million to spend. And there were 36 projects, each had a description, a photo, and a price associated with it. And so you had to make the same hard decisions that government has to make. So you have a limited amount of money, projects that exceed that amount of money. How do you allocate those dollars in a way that best fits what your vision for this part of the city could be? And people loved it. In fact, it's not dissimilar from ranked choice voting, but it allowed folks to say, all right, there's this $600,000 project that I could pick. That's going to eat up most of my $1 million budget. Maybe I should pick a bunch of smaller projects, or I spend a lot of time on this one street. I really want to see this street improved. I'm going to put as much money as I can into that street, given the projects that I'm presented with. And so we had 3,500 people vote. We looked across all the buckets of everyone's individual ballot, and we figured out pretty quickly which projects were most popular. And luckily, or maybe this is what happens when you invite everyone to vote and get as many people in the door as you can, the outcomes were pretty equitable across the geographic footprint where this was happening. And they ran the gamut from really big infrastructure projects or more expensive infrastructure projects to really small stuff. Because ultimately what happens is you're filling up your shopping cart and you get to the end and you got an extra $50,000 or $75,000, which is not a lot of money when it comes to public infrastructure. And people will pick some of the smaller projects to fill out that shopping cart. So we had one of my favorite projects was someone asked, there was a concrete island that divided a bike lane from a traffic lane, a vehicle lane. And they said you couldn't see it. Can you just paint it yellow? And it was like, I don't know, $1,000 or $2,000 to get it done. And so that project made it through because everyone kind of got to their shopping cart and they just needed to fill it out, kind of add in something to get to $1 million. And so these small projects got funded as well. And so it was a nice way to say, hey, you can support big and small stuff, but you get a say in it. What we learned pretty quickly at the end was a few things. And I think some of these lessons are applicable to voting. I know this is not as much of a legal presentation as many of the other presenters, nor is it as probably philosophically adept, but there are a few things that we took away. One is you could see a lot of voter excitement and engagement when the projects are delivered. So when you see the outcomes that you're voting for, people begin to trust the process and they want to re-engage. So we're just now seeing a lot of these projects get completed and come online, and we're having kind of a celebration around a new handicap accessible intersection, right? Or a new bike lane that gets put in, and we'll promote it and show that it actually worked. Someone in this community submitted this idea and now it's come to life. So that engenders trust and outcomes. The other thing is that we were really transparent and communicative throughout the process, partially because we wanted people to believe that this was possible, but we realized pretty quickly that just by communicating, here's the timeline, here are the steps, here's where to engage, here's what you can expect afterwards, people felt that they were valued and respected, and they were much more likely to spend their time telling others about it and voting themselves. And that's true, I think, for general elections as well. I have an acquaintance who runs elections in Maricopa County, Arizona, which is the biggest, most populous county in Arizona. It includes most of Phoenix. And they are surprisingly transparent and militant in their transparency so that folks understand and believe that the voting process is secure. And by that, my dog is barking in the background, so you may hear the dog. But by that, they go so far as to have, I want to say, over 10 cameras in a room where all the votes in the county are processed. And you can log on right now, even if there's no election. Well, there's an election going on now, but you can log on in the middle of February where there's no election. And those same cameras are live in that room. And you can see how these ballots get transferred from, I think they're electronic, but how the machines are handled, to how the hard drives are protected, to the printouts and what happens with the printouts and where they're carried. And there's this really refreshing transparency that anyone at any time can watch votes get counted. That goes a long way to making people feel like their system works and respects them, and that they should take the time to engage. And so we found that at ours is not that sophisticated, but and nor is this program meant to be one person, one vote, and nor is it a kind of winner takes all scenario. But just in going through that, I found that folks were really felt valued by the process. And if we can do that in our general elections, we can go a long way, I think, toward reinvigorating voter trust and participation. A couple other outcomes that I noticed from this process. One is you get stronger community connections. If, in this case, the participatory budgeting, because if you propose a project, you have an idea, you've submitted it, it makes the ballot, you're going to spend time talking to your neighbors and your friends, convincing them to spend time to vote. And that creates new community strength and civic strength that didn't always exist or may not have existed otherwise. We had a doctor who, he and his wife really wanted to see this street turned into a pedestrian only street. And they went around, to restaurants and shops in the neighborhood, asking them to put up signs to vote for this project with a link to the website, which we weren't expecting any of this. And to their credit, they probably met a lot of people they wouldn't have met otherwise. They got people involved in conversations about city making that normally may not think about city making, who may or may not even live in the city. And that was one of these beautiful outcomes that we saw time and time again from people who engaged in the process and had something at stake or something very personal at stake on the ballot. And the last thing I'll note is it pushes government to be more responsive. Ultimately, you're taking money that would otherwise sit in the transportation department or in the parks department or in another city department. And instead of allowing the department to decide how it's spent, you're saying to them, look, the public gets to decide how it's spent. You can put some guardrails on it with respect to legality and geographic footprint. But ultimately, even if you don't like this idea, if the public votes for it, you have to implement it. And that can be a very tough hurdle for city officials or civil servants to accept, because they may be professionals in transportation policy or in park management, whatever it may be. And so they're going to think they have the best ideas and they know what's best. But this is shifting the power dynamic a bit to say, no, actually people who walk the street every day or who, have their kids play in this park every day, they may actually see something that you don't see from your perch at City Hall. And we value that. And we're going to turn over some of the power to them. I'll close by saying, and I know that we have a little bit of time, so I hope there's some Q&A on it. But the more transparent and inclusive we can be in our voting processes, the more trust there'll be in the outcomes. They'll see higher engagement, and I think we can start to turn the corner on trust in governance, and frankly in elections, which is probably at an all-time low. I mean, we're constantly getting bombarded by all sorts of politicalization of the voting process. Some of it exists, from voter suppression tactics to just casting doubt on the process itself. But if we don't take these small lessons from programs like a participatory budgeting program, our democracy is really wobbly in the knees. And we owe it to ourselves, whether through the legal process or through just your own community civic activism and engagement, to boost it and to call for transparency and accessibility and how we allow folks to vote. So I'll stop there. I know that was a little bit, participatory budgeting is a little bit off kilter from most of the presentations today. And I'm not a legal scholar, though I'm a recovering attorney who used to practice at the same firm that Professor Chandler practiced at. But I hope this is somewhat, provocative or foster some thought on your end. And if I can be helpful in any way, I'm happy to do so. So I will stop there. And if there's questions, I'm happy to answer them.
All righty. Thank you so much for that, Councilmember Farokhi. I do also agree with you. And I think that moving forward, one big thing for not only citizens who do vote, but government officials as well, that, like you said, transparency and voting and things that are going on more so behind the scenes that the day-to-day citizen may not be aware of, and having a choice to be able to actually have a say in how the city looks or how things are implemented, I believe is imperative. One question we have for you, and just again to everybody who is here today, if you have any questions, be sure to use the Q&A section at the bottom of the screen. But moving forward, so what would you say to citizens who feel like their vote doesn't necessarily count, and moreover into local elections and how important they are?
Yeah, it's a great question, Cedric. I think, look, especially at the local level, it's easy to see how your vote matters because the numbers are frankly lower than a presidential election, right? I mean, you're having fewer, depending on when your local election falls. Ours happens to be in an off year where there's no presidential election, so the local elections are the only thing on the ballot, and you can see pretty quickly that folks are getting elected with 2,000 votes or 4,000 votes, which is a lot smaller than you see for statewide numbers, and the outcomes are really determined by whether people get their people to the polls. And so I tell my residents all the time that their vote really makes a difference, and they see it, right? They see it when I'm available or I'm not available, and so they say we can vote Amir in or we vote Amir out. But one of the things we looked at when we did the participatory budgeting program was we wanted to overcome the reality that the people who tend to engage with government tend to be affluent homeowners. That's who votes, or by affluent, I would say upper middle class and up homeowners. Renters tend not to vote or engage as much. Immigrants, low income folks, all types of these communities that should have a voice in city making or in state government, whatever it is, just tend not to vote. And so we said, even for this small project, this $1 million participatory budgeting project, we want to overcome the reality that if we did nothing, we just put it out there, you'd have the same 200 people that email my office every month participating. And so we went out of our way to try and find communities that don't normally engage with the city to let them know about the program, the opportunity, and then to really encourage them to submit ideas and to vote. And I think we were successful. And if you look at programs around the country and around the world, you see the same thing. Groups that are going into communities that may otherwise be ignored, whether they're an apartment complex that's 90% Latinx residents who are working service jobs and never interface with government at all, almost intentionally. Or you have renters, young professionals who graduate from Southern University Law Center. They're here for their first job, and they're busy working. They're not thinking about voting in a city council election. So how do you engage them in ways that show that their vote matters? Because when that person drives to work, or that person is walking down the street, if there's not a trash can every couple blocks, or there's a huge pothole that's always there, their vote actually makes a big difference whether that gets fixed or not. So that's a roundabout way to answer your question. But I think that in today's day and age, the power of the vote couldn't be more evident, because the extremes of our politics have been front and center for a while now. I think people realize that we do by nature of our vote, both at the national level and at the state and local level, we do determine the types of people who step into those seats and who would either invite us to the table or not. And I think if you need encouragement to vote at a time of kind of civic and democratic crisis, then maybe democracy is not for you. But I think we're hopefully trending in the right direction, as we're seeing from the voting numbers now, that folks will turn out when they feel like stability is threatened. So that's my quick reflection on your question.
Righty, thank you so much for that, Mr. Farokhi. Just another follow-up question, and kind of tying together what you were speaking about earlier. So you said that transparency in government is a big thing that people want to, or you have found that people, it gets them more involved, it gets them more willing to want to actually participate and be a part of the electoral and processes and things of that nature. So in this day of like social media and things of that nature, what do you believe are some solutions other than obviously the participatory budgeting that could possibly be implemented or done to kind of bring back that trust factor that you were speaking that has kind of been broken between citizens and government?
Yeah, let's look at that. There's a lot of ways to answer that question. I would say in the voting context, right? Like when it comes to election day or to the election period, you know, government and those who execute the election process, it's different in every part of the country, but whoever that entity is should go out of their way to make it as easy as possible for people to vote. And I'm sure y'all are well versed in all the different types of ways that we, and I say the royal we, all of us as a country, oftentimes one party over the other, can make it difficult for folks to vote. But I've noticed just in this year, the level of communication as to how to navigate the registration process, making sure that's available in multiple languages for folks who may be non-native English speakers, to make sure that it's very clear where the voting locations are, early voting and regular voting, and to make it as accessible as possible. And that, I mean, you see a lot of times voter suppression is oftentimes limited voting polling stations with limited machines. You know, here in Atlanta, we've had the benefit of the Atlanta Hawks and their arena being turned into a voting site. And it is remarkable. I mean, they have over 200 machines, and it's like going to like this concierge luxury voting process, right? I mean, they have their whole staff like opening the door for you, pointing you down this way, making sure you know where you're going. There's not a moment for you to feel unattended to or lost. And the volume of voters and the machines is so high that it just moves. And so it made the voting experience easy. They promoted it across the city because they want to see it succeed. That's, I think, one way to make it feel like, oh, I can trust this process because I showed up here, it's well run, I feel valued, and everything worked as it should work. Now, we all know that that's not the case in every polling precinct in the country or in the state. It's oftentimes left to local jurisdictions to run their process, and training varies and machine knowledge varies. And so I think if you're really going to make folks feel like their vote matters and they can trust the process, the lessons that I've learned from this cycle are make it as clear as possible what you need to do to be able to vote. And then when you go to vote, make sure for folks who are voting that the experience is a positive one. And that means not waiting in line for 7 hours to vote in the rain. And if there is a valid reason to wait in line for that long, to make sure that everyone is comfortable and has a chair, you know, all these things that say I'm valued in the process, because otherwise it makes you feel like you're trying to deter me from voting, and that's not what we want to see.
Definitely. Thank you for that, Mr. Farokhi. And I guess I'll kind of just finish up with this question until we move on. So just kind of speaking towards the day and age that we're into now, we're moving into more technology and things of that nature. The younger generation has kind of been not only brought up on, but kind of part of their daily lives as far as social media and using different platforms in order to speak of their differences or particularities or whatever the case may be. So knowing that this is something that is coming up as not only quick, but as prominent as it is as far as social media, how do you take something like that and use it to your benefit, being a city official and using that to help your campaign? And how do you think that holistically voting suppression or fake news and things of that nature on social media could ultimately affect your election or things of that nature?
Yeah, it's a great question. I think we're grappling with this as a country right now, that really the last kind of 4 to 8 years, we've seen the power that social media has, both to communicate with folks, but also to misinform them and divide them, right? Because we spend so much of our time online on these platforms, even the news sources that we self-select, you know, I think there's lack of trust in those institutions as well, right? Because we realize in some ways we're selecting information that fits with our worldview. And so it's very easy to divide and to misinform folks through those platforms. You know, I thought you were going to get at the question based on where you were going with it, of the comfort with, your generation, but also frankly, most of America at this point, with doing so much of their lives online, conducting so much of their lives online, including fairly secure things. Like we can board an airplane with a QR code or a boarding pass on our phone. When will we as a country embrace some sort of online voting, right? Where you can vote securely from your phone or your computer. I think I believe Estonia is 100% online voting. And you can do it in a way that's secure, and that there's very limited opportunity or zero opportunity for fraud. But we are a long way from that in this country. But to me, that's the next logical step to make it easy for people to vote, is if you can vote from your phone and it's secure and it's verifiable who you are and you're registered, like we should be doing that to make it super easy for folks and to create the period of time in which you have plenty of time to sit and kind of weigh your options. And Oregon is one of an increasing number of states that has vote by mail. All voting is by mail, and voter participation is through the roof, because if you get a ballot in the mail, which is an old school way to kind of communicate with folks, but if you get a ballot in the mail and you have a month to turn it back, I mean, you sit down at the kitchen table, you research the candidates, and you drop that thing off. It's easy. It's on your own schedule. You don't have to go stand in line. So I think there's both technological solutions and non-technological solutions to voter participation and making it easy. But when it comes to disinformation, I don't know. I think this is where you see a lot of national conversations amongst some of our political leaders talking about trying to break up Facebook or Twitter or limiting their political content, because it can be subversive and really dangerous to the health of democratic engagement and democratic conversation. And I don't think we've quite figured that out yet.
Alrighty. Well, thank you so much for that, Councilmember Farokhi. We appreciate you and all of the information that you've given us on today. Kind of just moving on with our panel here today.
Thank you so much.
Thank you. Alrighty. So I see we have Ms. Haney here. We also have Mr. Cunningham. So I'm not sure which of you would like to proceed first. I guess we'll go with you, Mr. Cunningham. So just like I said, moving right on along. Our next section will be discussing the suppressing the vote through partisan and racial gerrymandering. So here today we have Professor McKay Cunningham. He is a professor of law at the College of Idaho. So without any further ado, at this time, I'll turn it over to you, Professor McKay.
Super. Thank you so much, Cedric. I sure appreciate it. We are excited to be here and be a part of this discussion. The topic for today's event, representative government, voting and beyond, obviously timely, obviously critical. And the panel of speakers that you and Professor Chandler have brought together include a fascinating range. I really like the range, right, of academics, clergy, public officials, legal practitioners. This is the kind of diversity I think that we should bring to bear to tackle these kinds of very difficult issues. When President Obama was leaving the White House, he huddled with his most trusted advisors and tried to identify what it is that they ought to tackle post-presidency. What should they put their prestigious efforts and influence into attempting to solve? And what they chose was partisan gerrymandering. Partisan gerrymandering, which is a huge problem and is getting to be a much larger problem as we grow in our technological sophistication. At least once every 10 years, voting districts must be redrawn to account for population shifts. The critical question is, who draws those voting districts? In most states, it's the legislature that draws those new districts, a fact that has proved very harmful to democratic governance, because too often legislatures cannot avoid the temptation. They draw lines that benefit them. They draw lines that ensure that they will get reelected, that ensure, regardless of what the majority of voters say, ensure that their party will remain in power. And as mentioned just a moment ago, it is getting worse. There have been several academics who have chronicled over the past decade in particular the effects of technology on being able to draw voting districts so specifically that it really doesn't matter what the voters say. The outcome is predetermined. Latonia, in just a couple of minutes, Professor Haney Keith is going to show us some maps that illustrate the grotesque shapes that partisan gerrymandering has resulted in. I'm going to share with you guys some data that show how effective those maps are in ensuring that people who draw them maintain their power in office. And then we're going to talk a little bit about the fascinating correlation between party and race, and get into partisan gerrymandering along that way. Let me share my screen with you guys, if that's all right. And Latonia, let me know if you can see it. Can you see it up there?
I can.
Okay, super. Yeah, so here's a little bit of a roadmap, and then I'll turn it over to Latonia. Just a quick introduction and roadmap, because what I'm doing now, we're going to describe and define partisan and racial gerrymandering, identify its effects on the franchise, and maybe some of the remedies or models that could be brought to bear to lessen the negative effects associated with gerrymandering before hopefully addressing your questions. That is the plan. And so I'll just turn it over to you, Latonia.
Great, thanks, McKay. And let me add my thanks as well for inviting us to be here with you today. So before we dive into all the nuances that McKay already kind of alluded to in his introduction, we thought we'd first kind of define what it is that we're talking about. So the term gerrymandering refers to the practice of drawing electoral district lines in favor of one political party or an individual or constituency over another. And in light of certain examples that we're going to dive into in more depth here later, when this term is used in a more rhetorical manner, especially by opponents to a particular district map, it has a real negative connotation. But the term itself does not necessarily address the legality of the challenge map. And that's what we're going to dive into more today. So the phrase racial gerrymandering refers to the practice of drawing electoral district lines in favor of a particular race, or as it has been historically used, to dilute the voting power of racial minority groups. And the phrase partisan gerrymandering refers to the practice of drawing electoral district maps with the intention of favoring one political party over another. So how is this done? Okay, perfect, thank you. The picture on the screen that you see here, while it's simplistic, it's still illustrative of how one can manipulate the voting strength of a party or constituency by the manner in which we draw the district lines. With this mock state we see here on the screen, we have 25 dots for neighborhoods, and we must draw 5 districts. And when viewing the dots, there are 15 blue, so representing 60% of the state, and there are 10 red, which represents 40% of the state. And when drawing voting districts, we could use cracking as a gerrymandering methodology. So cracking reduces the voting power of a certain party or community by splitting its population and spreading its members around several districts where they essentially become an irrelevant minority. And in this instance, by using cracking, we are able to achieve a blue majority in all 5 of the districts. But alternatively, we could use what is called packing as our methodology. And packing really concentrates voters in one party or community into as few districts as possible. And this is to reduce their influence in the remaining districts. So in this instance, by using packing, we are able to achieve a red majority in 3 of the 5 districts. So why is this important today? And McKay alluded to this already, right? So at least every 10 years, voting districts must be redrawn, and that's to account for population shifts, and it's tied to the census. And it's 2020. And so this issue is very relevant today, particularly in light of the upcoming election. Whoever wins the seats in the state's legislature gets to redraw the voting districts, which in turn essentially means that whoever gets to redraw the voting districts really gets to determine who may be in power for the next 10 years until the next census. So we thought we would start by sharing some examples with you about how this has played out historically, and I'll turn it back to McKay.
Yeah, thanks. Just a real quick story that kind of illustrates what we're talking about. In the year 2010, right? There's a census, and so states had to redraw their electoral districts to account for population shifts. In Wisconsin, in 2010, for the first time ever, not ever, for the first time in 40 years, Wisconsin voters elected a Republican majority to both state houses, as well as a Republican governor. And so they had control of the House, and they immediately set upon the task of redrawing their districts to benefit their party. They hired a law firm, they hired a couple of political scientists who engaged in the technology that they could find using regression model to identify a baseline unit of geography that deals with partisanship. So they created this model, and then they presented it to a lot of the Republican Wisconsin politicians. This is what one of the politicians said, and this is a quote: "When I got a map, I could move the lines, see the party-based effects. It's a sort of a paint by number exercise." End quote. And the Republicans that were creating these different maps would go to Republican Wisconsin politicians and say things like, quote, "Are these areas that you like? Are there areas that you don't like? Are there areas surrounding your district that you like?" The politicians were being able to choose their voters rather than the other way around. And so the Republican politicians there in Wisconsin said, look, go back to the drawing board, give us some more maps. And they went back to the drawing board and they presented three basic maps: a basic, an assertive, and an aggressive. And guess which one they chose? They chose the aggressive, as aggressive as they could choose for the finalized map for all the redistricting districts there in Wisconsin. And at the vote, one of the politicians stood up and said, "The maps that we pass today will determine who is here for the next 10 years. And that was prescient and correct. The maps were passed in 2011, and in 2012, which this picture represents here, in 2012, you can see that the Democrats won the statewide vote by about 52%, but the Republicans won 60% of the seats, or 60 seats of the 99. Democrats only won 39 seats. How is it that the Democrats can win 52% of the popular vote and yet only get 39 of the 99 seats? They were gerrymandered out of power. In 2018, the same thing happened. 2014, 2016, and 2018. Here are the numbers for 2018. That was the blue wave. I don't know if you remembered that, but in 2018, Democrats won the statewide vote by 53%, almost 54%. Democrats swept all of the statewide offices. They got the governor, they got the attorney general, they got the secretary of state, but they lost the legislature. 63 out of 99 seats went to the Republicans. Only 36 of 99 seats went to the Democrats, despite the fact that they had won the state election by 54%, statewide vote by 54%. So Wisconsin's story is not atypical. In Pennsylvania, in 2012, Democrats won by 51% the statewide vote, but they only received 5 out of 18 House seats. That's about 28%, right? They won by 51%, they only get 28% of seats. In Ohio, Republicans won 52% of the House vote in 2012, yet they ended up winning 12 seats to the Democrats' 4. It's very, very lopsided. Do you notice anything, by the way, about those states? We're talking about Wisconsin, we're talking about Pennsylvania and Ohio. These are swing states, very important with regard to creating the very voting procedures that we've been hearing about at the beginning of this conference. But I want to make it clear that it's not just the Republicans. The Republicans are much better at it than the Democrats, but Democrats do it as well. In Maryland, for example, in 2014, for the House elections, Democrats won 57% of the vote, statewide vote in Maryland, and yet they got 87.5% of the House seats. And so you see how effective it is becoming, that it doesn't matter what the majority of voters decide, the results are to some degree predetermined. We see that illustrated in the maps themselves. Latonia, do you want to talk about that?
Yes, sure. So these kind of lopsided results that McKay is referring to has really led to some really interesting shapes when we talk about our voting districts. So we wanted to share a few of these examples with you. And what you see here on the screen is Pennsylvania's 7th congressional district as it has morphed over time. As you'll note, in 1952, it was a kind of cohesive, regularly shaped voting district. But over time, the state's legislature has increasingly altered its shape and is now considered one of the most gerrymandered districts in the country and is nicknamed Goofy Kicking Donald. But that's not the only problematic district in Pennsylvania. If we go to the next slide and we look at this view of Pennsylvania, you can still see Goofy Kicking Donald. That's kind of the reddish portion of the slide. But take a look at the district that's noted in green, and in particular, the little section at the top left of the screen. This is a prime example of cracking that we talked about earlier. That little section represents the city of Reading, and it's the 5th largest city in Pennsylvania. And the lines are drawn to put the Reading voters in the same district as Lancaster farmers, which really resulted in spreading out or diluting the vote of the poor urban communities in Reading among the more suburban urban areas out in Lancaster County. Another example of gerrymandering at its worst is in Ohio. Ohio's legislature in 2011, which was controlled by the Republicans, they pitted 2 incumbent Democrats, Marcy Kaptur and Dennis Kucinich, against each other by redrawing voting districts that created a single district that connected parts of Toledo to parts of Cleveland, 115 miles from each other. To do so, they created this really thin congressional district along Lake Erie that has now become nicknamed the Snake Along the Lake. McKay?
Yeah, there's this other very interesting phenomena as people try to effectuate change, try to stop the legislatures from creating voting districts that really just benefit the legislatures. One of the attempts to effectuate change is to draw attention to it. And here in North Carolina, there is a gerrymander 5K. And the 5K route follows the district. And here was where you would run if you signed up for the gerrymander 5K. Isn't it fascinating how specific it is? For some reason, this house right here is in this district, the 11th North Carolina congressional district, and all of these houses over here are on the 10th North Carolina voting district. But it illustrates the precision and the detail and that we are now seeing with regard to partisan gerrymandering and some of the negative effects that go with it. Here are a couple of other slides also illustrating those same things. From 2006 to 2016, this is where the voting discrepancy was. Notice there is no change. There can be no change in that voting discretion. In other words, Democrats would have to win approximately 55% of the statewide vote just to get one more representative. There's one little fact issue fact point I wanted to throw out, is illustrated pretty well by this slide. In Ohio, they found that Democrats can get 4 out of 16 seats with about a quarter of the statewide vote. But to get that 5th seat, they have to win by about 55% of the vote. So you see the big discrepancies there that lead to a lot of detriments. I think Latonia is going to talk about some of those detriments, as I see that we're kind of running short on time. Latonia, you want to take that?
Sure. So one of the reasons why we care so much, right, about this is that if we want a real properly functioning representational democracy, partisan gerrymandering, as McKay is showing in the slides, can be a real problem. You know, it's eventually, if the opposition is really neutralized, there are so many negative consequences. One is that our government's less responsive to us, right? Essentially, partisan gerrymandering lets our government officials choose us rather than us choosing them. There's less accountability, there's less compromise. We've certainly seen that in the gridlock that we've experienced with the shutdown of the federal government. There's really little incentive to compromise if we're winning by huge margins because of partisan gerrymandering. There's also less ideological diversity, which at least to me means that our country isn't innovating. We're not facing and solving our myriad of issues. We just stagnate, right? And hit against each other, and soon we'll just watch many other countries pass us by. And then finally, you know, gerrymandering leads to less institutional legitimacy and voter apathy and disillusionment, right? So we see that voters, and we're seeing this now, right? Voters respond and participate in close elections much more than elections that appear predetermined. And so the public's faith in and their goodwill towards governing institutions begins to really decrease when the public has very little influence over them.
Yeah, that's right on the money. One thing that I would add in there is that if the general election is predetermined, like if you know because of partisan gerrymandering that this party is going to win, then it all boils down to the primary. And in the primary, what that requires is the person with the candidate with the most extreme views are typically going to be elected in the primary, which causes greater and greater entrenchment, less and less compromise. Lots of problems associated with partisan gerrymandering. So why is it around? Why do we still have it? Why do we allow it to happen? The principal reason is because it's the legislators who are the people who are in charge of changing it, but they are the ones who benefit from it. On top of it, it's deeply entrenched. Here's a picture of Elbridge Gerry. He was one of our founding fathers. He was around in the early 1800s, and this is where the term originated from. He drew a district so grotesque that it looked like a salamander. To me, it looks like a dragon, but back then in the 1800s, it looked like a salamander. So you use the word Gerry and salamander, you smash them together and you get gerrymandering, which is what we really ought to be calling it if we were being hyper technical. But it's been around for a long time. In fact, one of our very first Congresses, that's the attempt of Patrick Henry to cut out James Madison by using gerrymandering in our very first Congress. It's been around for a long time. And unfortunately, in 2019, just very recently, the Supreme Court said, sorry, we agree that extreme partisan gerrymandering is theoretically violative of the Equal Protection Clause. It theoretically violates the Constitution, but we're not going to get involved. You're going to have to solve it some other way. This is not the role of the court. And so all of that to say, guys, partisan gerrymandering, very detrimental, very hard to change. Typically, it would fall to the court to change it, but the court in 2019 just said that it will not do so. Latonia, you want to talk really quickly about racial gerrymandering?
Yeah, so we wanted to at least shift a little bit to racial gerrymandering, and like partisan gerrymandering, which McKay just articulated, the Supreme Court has clearly stated that racial gerrymandering violates both the 15th Amendment and the Equal Protection Clause under the 14th Amendment, and that it will step in and intervene when states engage in racial gerrymandering. So it's really drawn a distinction between focusing on racial gerrymandering, and will step in when state legislatures are redrawing the voting districts to harm racial minorities, either by packing them, as we talked earlier, into a single district, or more often cracking them across non-minority communities to deprive them of representation. So if voting districts are drawn on racial grounds, strict scrutiny applies, and then typically the courts will strike them down. And the ways in which the courts have done this is that they will look to see whether the district is a grotesque shape, some of which we've already seen, and whether the predominant purpose for redrawing the district is racial. And today, though, what we want to make sure we at least cover a bit is this kind of fascinating issue of the intersection between racial gerrymandering and partisan gerrymandering. So I'll turn it back to McKay to give us a little more on that.
Yeah, I just want to identify the issue and open up the panel for questions if anybody has any, because if you let us do it, we'll talk for 7 straight hours. The one thing that we wanted to identify is that there's a correlation oftentimes between partisanship, between what party someone affiliates with, and race. So if we know that partisan gerrymandering is legal, it's okay to do it. But racial gerrymandering is illegal. What happens when there's a high correlation between race and party? For example, I don't have the stat right in front of me, but in North Carolina, for example, 80% of adults who are of voting age that are African American identify with the Democrats. Is it possible to draw a line in which you're saying that all you are really doing is trying to gerrymander a district in favor of the Republicans, when what you're really doing is diluting a minority vote? That's a really critical issue that has been at the forefront of the court's attention in 2017 and beyond. That having been said, we'll be quiet for a little bit to see if anyone has any questions about what we presented so far.
All righty, thank you guys so much for that. Just speaking to our audience once again, if you guys have any questions, make sure that you use the Q&A section at the bottom of the Zoom link. I did have one inquiry. It's more, I guess it's more of a hypothetical than an actual question, but let's see how this fares out. So in the process of gerrymandering, obviously it's government led and it's done through the different public officials of each district and or county, et cetera. So hypothetically speaking, once again, as a citizen or a solution to gerrymandering, what do you guys think about maybe creating some type of panel, a diverse panel of citizens within the different districts and or counties to be able to kind of work in conjunction with the local governments and districts in order to make sure that everyone is properly represented for each county and or district, if that is possible. If not, what kind of problems would we run into, and so on and so forth.
Fantastic. Latonia, do you want to take that one? Or you want me to take it?
I'll let you start and then I'll weigh in.
Yeah, thanks for that question, Cedric. It's a really good one. And there are a number of states that have independent commissions that are in charge of drawing voting districts. And that's a fantastic thing. The problem is that it's really difficult to get an entire state to go from the legislature drawing their own voting districts to an independent commission, because it's the legislator's decision to do so. So how is it that those states have been able to change the power of drawing lines from the legislature to independent commissions? It's typically when those states have statewide referendums that go around the state legislature. If you have a statewide referendum, then the voters come out and they can supersede the legislature itself to create an independent commission that then draws the voting district lines.
Yeah, the one thing that I will say to that is, McKay and I have been teaching a property and race seminar this semester, and even though I've been teaching housing law for some time, it's given me an opportunity to really step back and remember and understand our history, and starting with slavery and moving forward to housing policy and how that creates our housing landscape today, and where people live have a tremendous impact on how the concept of how to draw electoral districts. And so that endeavor, even if we have independent commissions, or even if we have representatives from the citizens to weigh in, that endeavor, even by well-meaning state legislatures or independent commissions, is really challenging, especially in urban areas, and is impacted by our history, particularly in light of redlining and racially restrictive covenants that were efforts that furthered segregation. And so as we think about this, even if you were attempting to sit down and do this yourself, and to do that fairly, and to ensure everyone has a vote, and to make sure you're not discriminating, it's a really hard endeavor. And it's just something that I think is going to continue to be a problem for us as we move forward.
Alrighty, thank you so much for that information. We have a question from our audience. So a member from the audience asks, has the court ever tackled the distinction between correlation and causation in racial discrimination? And that's for either of you to take.
Yeah, thank you, Kane. Great question. Yeah, if you are asking whether or not the court has really squared off with regard to the fact that oftentimes there is a high correlation between race and party, the court certainly has. I don't know that that's what you're asking. It seems like you may be talking about causation, but at least with regard to the correlation between race and party, in some instances, the court in Easley versus Cromartie, that's a 2001 opinion, said it's perfectly fine for a state legislature to use race in drawing electoral district lines, as long as they blame it on a partisan result. And that was the law for a long time. But in 2017, in Cooper versus Harris, the court backed away from that. The court said, look, okay, from now on, if you use race as a predominant factor in drawing your voting districts, then strict scrutiny will apply, and that voting district will likely be struck as violative of the Equal Protection Clause. Thanks for your question, Kane.
Yes, thank you, Kane. We appreciate it. I believe we have one more question from our illustrious Professor Chandler. If she's still here. You there, Professor?
I am. Hello, welcome to Professor Cunningham and Professor Haney Keith. Good to see you both. Thank you for being here today. I have, so on the one hand, this is really interesting, very important information. On the other hand, it's a bit depressing when you think about, if you're a person who's not a con law scholar or engaged in that kind of work, but you're concerned about this potential problem. I mean, that fantastic point about, we're not choosing our elected officials, they're choosing us, right? I mean, is there anything that sort of the normal person can do to try to bring light to this potential problem, right? And like, how do we draw the distinction between partisan gerrymandering and racial gerrymandering? I mean, is there anything we can do, I guess is what I would ask. Any suggestions or thoughts in that regard?
Well, I think by continuing to have conversations about this and getting in front of our state legislatures and attempting to educate them about what's really happening here, I do think, and maybe McKay has other ideas here, but I do think that we're becoming more and more polarized in the ability to kind of try and make that correlation between race and politics puts a really interesting overlay in light of what the court has said in Cooper v. Harris, and in particular what they've said about whether or not they're going to weigh in partisan gerrymandering. And I think that's partly why they're not weighing in, is that it's become so challenging to figure out how to do this and how to do it well that they themselves are not planning to weigh in and provide some direction here. And so I think we've got to continue to maybe work through some innovative kind of solutions. I see that McKay's put the lovely board game up that they have about gerrymandering, and to try and educate about, how difficult this is, and really maybe wouldn't it be lovely to start over from scratch to figure out exactly how to make sure that we've got a representational democracy and not what we've continued to do going forward, which is more kind of entrenchment and separation. McKay, do you have?
Yeah, I know that we're at time, so I'll just be very, very quick. I think raising awareness is one of the things that we as individuals can do. We can raise awareness in different ways. Like this 5K here was a really good way of raising awareness about how crazy these districts are, as well as even board games and the like as individuals. But then the last thing we can do is see if our state has a referendum process and start getting engaged in a referendum process. If our state does not have a referendum process, then federal Congress can actually create laws that limit the effect of gerrymandering.
Thank you both. Even trying to offer us some solutions, I appreciate that. It's a challenging problem, as you two both have laid out, but thank you. Okay, so now we'll move to, I'm gonna have the pleasure of introducing Dr. Ernest Johnson. Dr. Johnson is actually an alum of the Southern University Law Center, and he's the executive director of the NAACP here in Louisiana. He also teaches here at the Law Center. In addition, he's had a long and illustrious career, done lots of different things, but in particular for today's purposes, he's been really involved in some really interesting and important civil rights litigation. So without further ado, I'm going to turn it over to you, Dr. Johnson.
Good morning. Can you hear me?
Yes, sir.
Good morning. Thank you very much for inviting me to serve on this panel. And I want to thank Professor Chandler and her co-host, Mr. LeBlanc. And it's been very interesting hearing the discussions that have gone forward in this game of war that we play in the United States of America for people to just simply to have the right to exercise their right to vote. It is the most amazing thing for us to participate in this journey of freedom in America. And I'm just thankful that the Lord has used me to play some role in it. When Professor Chandler called me and talked to me about being on the panel, I said, I would like to talk about judicial elections. She said, judicial elections? I said, yes. And the reason why, in 1976, I finished from Southern University Law School and became an attorney in Louisiana. And in 1976, out of 350 judges, and that's district court judges, appellate judges, and Supreme Court justices. Out of 350, only 5 were African American. 3 out of New Orleans, 1 in Baton Rouge, Freddie Pitcher, who later became the Chancellor of Southern University Law Center, and then 1 judge, a district court judge, up in Shreveport. And a group of us who finished in my class, Judge Janice Clark, and others, felt like it was just something wrong with that picture. You know, when we look at those the maps and how the districts are drawn, and when you really take a snapshot at it and look at it, and you look at it and say, wait, there's something's not right with that district. Currently, we have a congressional district, the 5th congressional district. It comes from the top part of the state on the east side. It comes all the way down. It jumps across the Mississippi River at Point Capee Parish, and then it snakes across the top part of the state into what we call the Florida parishes. And when we start looking at stuff like that, it just doesn't make any sense. Voter suppression doesn't make any sense. And so not only do we play defense, but we play offense also. And in playing offense, we thought something was wrong with the way the court system, the system in which we as attorneys were participating in. There was just something wrong with that. So there are 3 cases I would like to focus on today. The first case is entitled Clark versus Edwards. The second case is Chisholm versus Edwards. And then the last case I would like to focus on is a case that the 5th Circuit ruled on this year. It's called Fugile versus Landry. And that's Reverend Vincent Fugile versus Attorney General Jeff Landry. And the NAACP was involved. Well, NAACP Legal Defense Fund litigated the case, and the NAACP in Terrebonne Parish was one of the plaintiffs. So let me start with the Clark case. In 1986, there was a case that had been decided by the United States Supreme Court named Thornburg versus Jingles. And basically, the Supreme Court said in that case is that rather than look at the intent of the legislation, that the totality of the circumstances would use to determine whether or not we had violation of a dilution of Black voting strength under Section 2 of the 1965 Civil Rights Act. And it's interesting that we had this panel discussion a few months after Congressman John Lewis passed away, and we had his funeral. Because really, it was really Congressman John Lewis that instigated the 1965 Voting Rights Act. And we all know the story: Edmund Pettus Bridge, Bloody Sunday, Dr. King and others came in the next week, and the rest of it is history. Because President Johnson had just signed the 1964 Civil Rights Act and really did not want to do the 1965 Voting Rights Act. But again, we play offense, we play defense, but we play offense, we win. And we got the 1965 Civil Rights Act, but it was not really until Thornburg versus Jingles, which was reported in 1986, that the Supreme Court used a different standard. Because we understand that we had the Reconstruction Amendments, where we got the 15th Amendment to the United States Constitution. But that intent theory, how do we prove in my mind that I want to discriminate? Because as we know, nobody discriminate against anybody based on race. Ask Donald Trump. So as a result of that, the Supreme Court said, wait, we're going to change the way we're going to do this analysis. We're going to use these different factors. And the factors weren't exclusive. You know, we're going to use these 7 factors. And if you can prove these factors and you can draw these lines, then we will agree with you that it's vote dilution and that we should have some form of remedy. So there were 2 cases that came out of Louisiana. The Clark case that we filed initially in East Baton Rouge Parish. I was lead counsel on that case. Judge Janice Clark, who was my classmate at that time, became the named plaintiff. Arsini Beard, who finished from Southern University Law Center, was on that case. Eddie Crawford and who we always call Mr. Rayford. But Mr. Rayford was Miss Clark's husband at the time, and he taught at the law school too, Norbert Rayford. But he was willing to go along with us on the case. And Murphy Bell, who had the Voter Information Project. So we had to, at that point, the old and the young, and we were going to go fight for equal rights in the judicial system. We had seen legislative lines drawn to allow majority voting districts. We've seen city council races, school board races, but nothing in the area of judges in Louisiana. And remember, we only had, at that point in time, 5 African-American judges out of 350. So we filed a case. The Lawyers Committee ultimately came in. Rob McDuff came in as the trial counsel. The Lawyers Committee came in to help us. And we had a combined, consolidated, cooperative effort among the African-American attorneys in this state to see if we could seek a change in the judicial system. And actually, a lot of people are not aware of it, but a lot of district court judges were on our side. They could recognize that there was something wrong with the picture, but we did not have African-Americans who were serving in the judicial system. And so Clark versus Edwards was filed, and it challenged the at-large system for electing judges in Louisiana. At that time, Louisiana, we still do have elections at large, which would be, say, parish-wide, county if we're not in the state of Louisiana. And then we would have divisions, A, B, C, D. But all divisions would run, not all together, but they would all run at large by division. And that case went to the Supreme Court. Clark went to the Supreme Court on the issue of whether or not Section 5, and I noted earlier that it was discussed, Shelby County versus Holder was discussed, but at that time, in 1987, 88, Louisiana had almost 350 judgeships that had not been pre-cleared with the Justice Department. For some reason or another, the state of Louisiana thought that after 1965, that judicial elections were not considered elections because judges are not supposed to be representatives. And so those judgeships were not pre-cleared with the Justice Department. So we had the state kind of locked in on not having pre-cleared the 350 judges under the Section 5 pre-clearance administrative rule, which was a good tool for us to use. I would like to see that come back again. I'm in prayer that it will come back, because in these southern districts, we were really able to use Section 5 to stop a lot of voting changes that didn't make any sense. And I can tell you, Louisiana have been coming up with a lot of voting changes that don't make any sense since the Shelby County case. So that case went up. The United States Supreme Court ruled in Clark that Section 5 of the Voting Rights Act did in fact apply to the election of judges. There was a companion case. The second case I want to make note of is called Chisholm versus Edwards. And let me just say this about Clark and Chisholm. First, it started off as Chisholm versus Edwards. And then when Buddy Roma was elected governor in 1987, both cases became Clark versus Roma, and then Clark versus, and then Chisholm versus Roma. And then it went back to Edwards. Both of them went back to Edwards in 1991 when Governor Edwin Edwards beat the Ku Klux Klansman, David Duke. That happened in 1991. And both of those cases were settled in 1992. And the result of the settlement was the creation of majority African-American voting districts for district courts in the state of Louisiana. And for the Court of Appeals, came out of Clark. And Chisholm applied to the Louisiana Supreme Court case. Chief Justice Calagaro and Justice Marcus were both elected from one at-large district in the New Orleans area, but they were like by divisions. And while the Louisiana Constitution required that the Louisiana Supreme Court reapportion itself after the census every 10 years, it was not being done. And as a result of that case, we resolved that one with Governor Edwards. And the way the Chisholm case was settled was that we created one extra seat on the Fourth Circuit Court of Appeals, which is down in New Orleans. And that particular judge who was elected ended up serving on the Louisiana Supreme Court. So for a while, although we have 7 Supreme Court justices, for a while we had 8 Supreme Court justices in Louisiana. Justice Rivas Artigue, who finished from Southern, became the first Black to sit on the Supreme Court for the state of Louisiana. And of course, later on, that seat, after Justice Caligari and Chief Justice Caligari and Justice Marcus resolved their issues, and one of them didn't run again, then that seat is a seat coming out of New Orleans that's currently represented by Chief Justice Bernard Johnson. So that was Chisholm and Edwards. Chisholm went to the Supreme Court also. Chisholm went on to the Supreme Court, the United States Supreme Court, on the question of whether or not Section 2 applied to the election of judges. And of course, the Supreme Court heard both of those cases at the same time. And the Supreme Court ruled that Section 2 of the 1965 Voting Rights Act applied to the election of judges. So we started off with 5 in 1986, and now we have more, as my understanding, judges elected per capita than any other state in the United States. I never became one, but I have a lot of them that I know who call me all the time and ask me to do this, that, and that. I think it was a great victory. I think it was a great victory for attorneys in the state of Louisiana and ultimately for judges in the state of Louisiana. But I'm concerned. And the reason why I wanted to target this discussion and wherever I can do discussions is we can win on liability and then we could lose on remedy. And the reason why I wanted to bring that up is another case. It's not one of my big 3, but it's called LeBlanc versus Texas. And it came up to the Fifth Circuit right after Clark. Now what happened, Clark was on appeal to the Fifth Circuit, but Governor Edwards had made a commitment that he would settle the case and create the sub-district, what we call sub-districts anyway. People ask, what is a sub-district? And I knew that the judge in our case, Judge Parker, would never go with single member districts for judges. We read the law. We do on a remedy phrase that because they didn't consider judges to be representatives, that we couldn't get it through. And then one day I was talking to the Lord. I said, well, Lord, how are we going to get this done? And he said, well, just call it sub-districts. And I say, sub-district? He said, yeah, just call it sub-districts. So how you going to explain that? And one day I was in, like we do the status conferences, I was in the chambers with Judge Parker. He said, what is a sub-district? I say, well, what we're going to do is we're going to take a lot of those divisions and we're going to throw them into one district. It won't be a single member district. It's going to be a sub-district. He said, I like that. So we ended up with sub-districts coming out of Clark. And we have sub-districts today where we would take maybe 3 or 4 of those divisions and we would put those into the sub-districts. So like in East Baton Parish, we created 3 sub-districts, 1 in the north, 1 in the center, and then 1 in the southern part. And that's how we came up with sub-districts. But LeBlanc came right after Clark. We settled Clark and we did a dismissal at the Fifth Circuit. So that would never be litigated again. It'd be double jeopardy, in Louisiana, we call it res judicata, but that would never be litigated again. But LeBlanc came up right after Clark in the Fifth Circuit. Fifth Circuit reversed LeBlanc. And the Fifth Circuit judges, that panel said they could not even imagine, like in Harris County, I think you have over 300 judges in Harris County, which is Houston, judge being elected based on single member districts where one of the projects over there, housing projects over there, could select or elect their own judge. And they didn't buy it, they kicked it back. And there's another case that came out a couple of months ago out of Terrebonne Parish. The name of that case is Fugile versus Landry. Reverend Vincent Fugile versus Jeff Landry. And now that case is troublesome because the district court judge had found liability under Section 2. But the Fifth Circuit most recently came back and said that, well, there was a number of issues in it. One, Jeff Landry, who was not a party to the case, was able to take the appeal because the governor decided not to take the appeal, which means that the plaintiffs in that case would have won an extra seat. It was, of course, in about 4 seats down in Terrebonne Parish, and they just made the 20% to qualify out of 5. But the Fifth Circuit, in this dictum, in the language of the opinion, made some troublesome comments about what type of remedy could be in judicial elections, and that's why I wanted to put it on the table. I think that for litigation purposes, in light of what may be what might be the type of justices on the Supreme Court in the future, I think we need to take a look at our remedies and see what may fit, because I think that over a majority of the Supreme Court members might not like single member districts. And so I think that we should consider peer at large seats. I think that we should consider plurality voting, where if you got 5 and 10 running, take the top 5. I think we're going to have to come up with some new thoughts as it relates to our voting rights litigation. The other problems still exist. Voter suppression so that they can stack these legislatures. Denial of the right to go to vote. It's all going back to Reconstruction. Because when Lincoln was assassinated, he wasn't able to really implement Reconstruction like he wanted to. And his successor, who is kind of like the father of modern day supremacy, whose name was Andrew Johnson. I just don't like it, the fact that I got the last name Johnson, but I got to live with it. It's going to cause us to have different thoughts on how we fight on these different levels. And so I think that, we ought to start thinking about how do we craft remedies in voting rights cases once we can get past totality of the circumstances, whether we can establish that these districts are cohesive, demographically, we can draw districts that's compact and we don't have to worry about overpacking so that we can leave some folk in different areas. After we get past all of that, we're going to have to start focusing on what are going to be the remedies in these cases, because I think by next week, regardless of how Roberts decides he wants to rule, I think that we're going to have to wrestle as a result of somebody coming out of Louisiana. We're going to have to wrestle with a 5 majority against voting and civil rights in the future. That's my comments, and I'll be available for any questions that you all may have.
Thank you. Thank you for that, Dr. Johnson. I just remind the audience, feel free to send questions along. And I will ask a question that I've actually posed to a couple of our panelists, and that is, to the extent you can give us something that we might do to help with these issues that you've raised, these potential concerns. Those of us who are involved in litigation and focused on this kinds of litigation, we can certainly start thinking about appropriate remedies and how to fashion a way to respond to the problems that you're seeing. But for those of us who are not either practitioners, so we have some non-attorneys on the line, or for attorneys who don't practice in this area, do you have specific recommendations for things that we might do if we have concerns regarding the way judges are being elected and the various obstacles that may be in place to having a representative bench?
Right. Well, because of precedent, I think that the Supreme Court, whoever's currently sitting on the Supreme Court, has to go with precedent. I think that what's going to happen that we will see is how you get around it, right? So if there's no question about liability, I don't think they're going to overturn Thornburg versus Jingles because it's not ever discussed. So I don't think that'll be a target. of the Supreme Court, but what they're going to do is look at the remedies. And I think from a teaching perspective, from practitioners, the more meetings like this we have to start thinking out of the box. We cannot think the way we thought 10 years ago, or even 15 years ago, because we're going to have a new Supreme Court. So the law itself has not even been decided at this point. So it's good for us to think. I've always thought that, well, I don't like appointed because that means that voters aren't voting, you know. So, and I know that there have been people who advocate appointed, but I don't like appointed judges or anything else. I think that the voters need to speak. So our question is, how do we protect the voters? We want to protect the voters to be able to register to vote, to be able to vote. And then after the voting is over, which I thought this is where we were going here, to protect what the remedy is going to be, and not allow the Fifth Circuit. We know that the Fifth Circuit and judicial elections are going to do whatever they can to circumvent voting districts. Don't like them, just don't like them. Don't like a concentrated of voters deciding how a particular vote is going to be cast. So how do we get around it? And again, if we stay in the mindset of being offensive, and we say, well, okay, I'll tell you what, we want to have pure at large. And they said, what that mean? Well, we got 5 seats. We want everybody to run. And then the top 5 vote getters. Because incumbents, who most of the time are white, sometimes black, incumbents want to protect themselves. Anybody in office want to get reelected. That's the drive. And I think what we need to do is become more aggressive in terms of what we put on the table to say this is what we want. Because what we found that in the judicial election, the judges, once we said to the judges, this is what we'd like to have, they had to consider their positions. And then at the end of that case, the district court and appellate court judges were going with us and supporting our side. So I just think we got to think out of the box. We got to plow new ground on remedy, accept the fact that we can win in most of these cases because they're not going to change the law. You know, you got a Democratic House of Representatives after this election. Who knows, we may even have a Democratic controlled Senate. Democrats have been more kinder to African Americans and other minorities than Republicans. Right now, we have a Republican legislature in Louisiana, 2/3. And we don't tend to get the kind of legislation that support our causes. So we might have to just consider holding what we got right now and then fighting for new ground based upon the ground that we've already plowed. That's what I'm thinking.
Well, thank you for that. I appreciate your ability to summarize all that interesting work and all the ground that's been covered. And you did it in a very concise way. So thank you for that and made it digestible for all of us. So I appreciate that. I am now going to introduce our next speaker. So our next speaker is the Reverend Dr. Jonathan Augustine. He is the pastor of St. Joseph AME Church in Durham, North Carolina, my home state. So like that. And he's been involved with civil rights litigation. He also has a JD, but he's here today to talk about the role of faith communities, the role they might play or do play and have played in civic life, in civic engagement. So I'll turn it over to you, Dr. Augustine.
Thank you. Thank you so much, Summer. And thank you for the invitation to be here with you. It's an honor to be a presenter, and it especially is an honor to follow Dr. Ernest Johnson, someone for whom I have all the respect in the world. Now, I want to begin by sharing that my mother taught me as a child, you don't talk religion and you don't talk politics at the dinner table, and you don't talk them with people that are not your family. Well, today we are all going to become family. Otherwise, I'm going to have to break that rule, because the heart of this presentation really goes to those two hot button core issues as we talk about access to government and access in particular to the right to vote, because we're going to talk about religion and politics. Now I'm going to start my timer. I understand we are on a strict timeline, so I want to make sure and adhere to the time that we have. We have a slide presentation, and do you have that, Ms. Summer?
Yes, give me just one moment. I'm having a bit of a technical challenge.
No worries.
It worked out. Just one moment, please.
No worries. It's all good. Thank you so much.
Okay, do you see it there?
No, there we go. All right, good enough then. So the presentation, and is it possible to enlarge it at all? There we go. All right, so the presentation I would like to share with you today is entitled Obstacles and Opportunities, a historical overview of faith communities in citizen participation. Next slide, please. I want you to think about the dichotomy that this represents in terms of obstacles and in terms of opportunities. The picture on your left depicts a pre-Civil War, pre-Reconstruction. This is slavery. This is where African Americans began, going back to 1619 in cotton fields and enslaved. So those are obstacles, obviously, social obstacles. But the picture over on the right represents opportunity. It represents what the Voting Rights Act really meant at its finest or at its highest point, when someone from a marginalized community could hold the highest office in the land. Obstacles and opportunities. Next slide, please. The picture on your left, again, there are obstacles. There is John Lewis, and reference has been made to him having gone on to glory this year, but he will forever be a hero because of his role in advocating citizen participation, and particularly for the blood he shed on a day known as Bloody Sunday, March the 7th, 1965, when he and others marched across the Edmund Pettus Bridge. As a result of their heroism in March of 1965, August of 1965, August the 6th, meant the Voting Rights Act became law. And the picture on your right there is obviously President Johnson signing the law and giving the pens to Dr. King and others who were there with him at the White House. Next slide, please. Next slide, please. Okay, I want to undergird that the movement was led by members of faith communities. So the country has a rich history of both obstacles and opportunities with respect to citizen participation. In this presentation, we overview how faith communities have been both a part of the problem and a part of the solution. Now, I want you to look at those who are depicted in the front row of this march, or those leading the march. Andrew Young to the left, an ordained minister. Ralph Abernathy, an ordained minister. The Reverend Dr. Martin Luther King Jr., obviously an ordained minister. And to his right, John Lewis, also an ordained minister. Next slide, please. By way of an outline, what I'd like to cover in the remaining 20 minutes is to talk about and really frame the Voting Rights Act of 1965 from a faith-based perspective, how it came into existence, and laying a groundwork in how the faith community led the conscience of America into passing or enacting legislation to protect minority voters. I also want to talk about the role faith leaders played in advancing opportunity and overview the theology behind their fight for opportunity. If you think about some of the things they did, putting themselves in harm's way, very, very counterintuitive, very, very counterintuitive, but people were willing to sacrifice themselves and literally put their lives on the line because they believed in a brighter or a better day. And that belief is undergirded by faith. And I want to talk specifically to some doctrines that I believe undergirded the movement. I also want to connect our past with our present in terms of where we are today and how we are continuing to see incarnations of faith play out on the right and on the left with respect to citizen participation and the advocacy of opportunities, or advocating denial of opportunities for that matter. As we prepare to close, I want to reference Dr. King's fourth and final book, published after his untimely assassination in 1968, and ask the proverbial question, where do we go from here? We are on the eve of an election. I think we're 11 days away, and the question really becomes, with the country as divided as it is now, where do we go from here? I want to conclude then with questions and answers. If you have questions, I just hope I have some answers, right? My attempt at levity. Okay, next slide, please. If there are any goals I wanna reference for this workshop or for this brief CLE, faith has undergirded civic participation from the beginning of time, but for the purposes of our presentation, certainly since Reconstruction, the end of slavery, and into the civil rights movement, and that fight continues today. As we think about many of the divisions in our country, I see the fight or the advocacy for rights, or those who are advocating for opportunity, as being members of faith communities. So I really want today's presentation for you to walk away with an understanding that faith is not just a noun, faith is an action verb. It is also my hope that we will develop a better understanding of how the faith communities have played, or the role they have played rather, in advancing opportunity and access for all citizens. And all really does mean all. Next slide, please. Framing, I want to frame how we got to the Voting Rights Act of 1965. So the picture on your right depicts Hiram Revels, who I'm proud to say I'm ordained and I serve in the African Methodist Episcopal Church. Hiram Revels, the first African-American to serve in the Senate from the state of Mississippi, did so in Reconstruction. He also was an ordained minister in the AME Church and served a wonderful congregation in Natchez. Reconstruction created opportunities, but in as much as it created opportunities, there was also backlash. So the 15th Amendment was enacted or came into existence, in theory at least, to guarantee the right to vote to those who had previously been enslaved. Backlash, however, came about from organizations like the Ku Klux Klan. In fact, in 1970, Congress enacted the Enforcement Act of 1970, also called the Ku Klux Klan Act, to prevent or to make illegal much of the violence that was going on as retribution for the advancement that so many African Americans now enjoyed as a result of the Reconstruction era. Next slide, please. So we're talking about faith here, right? The image on the right is horrific as that is. Look at the symbol behind them, and what is burning is a cross. These are people who held on to a special kind of faith, but these are people who were members of faith communities. The Ku Klux Klan was largely a white Protestant organization, right? The 15th Amendment passed during this time period, and I'm summarizing parts of it. It says, the right of citizens to vote shall not be denied on account of race, color, or previous condition of servitude. So it's during this period of Reconstruction where we had a rise in prosperity and opportunities for African Americans, as well as a backlash from white vigilante organizations like the Klan. The Black church really began to flourish, especially in the South. Next slide, please. So in the period immediately following Reconstruction, some people call it the period of redemption. Whenever there's an action, there's always a reaction, right? So this is a period where many of those who believed in white supremacy wanted to redeem themselves. We started to see the erection of Confederate monuments. This is a way to preserve what once was and what was felt to be lost, to show that white supremacy still reigns supreme. After this period of redemption, we then usher in the Jim Crow era in the wake of Plessy v. Ferguson, where we start to segregate based on race, and obviously separate never came to fruition to mean equal. Next slide, please. Faith communities then, we're moving into the 1900s. Now, faith communities then started to play very divided roles, but very defined roles in the fight for advocacy, or in advocating for rights or opportunities, but also in advocating against opportunities. There were those adherents who were part of the religion of the lost cause. And what was this? There are passages of the Bible that can be, I believe, misconstrued in many ways. In particular, there is a very popular passage from Genesis called the curse of Ham. This isn't the time to unpack that, but if you take my word for it, it has been used by many to say that those with brown skin are cursed and those with lighter skin are favored by God. Therefore, they are supreme, or the supreme beings. So this religion of a lost cause, the faith adherents there, these are white Christians primarily, wanted to return to a pre-Civil War white supremacy, and they advocated positions of such. On the opposite side, you had liberation theologians who wanted to advance egalitarian opportunity for everyone because we all are God's children. I put the image of this book, White Too Long, up. It's one of the last books I read, a very, very, very compelling read, and it really breaks down for you the tension between these two faith camps that I'm attempting to unpack today. Next slide, please. So now, as we're moving past the early 1900s into the 1930s, 40s, and the 1950s, all the action that was going on, the dichotomy between these two faith groups, there is a debate, if you will, a friendly debate on when the civil rights movement actually began. Some people say the movement began with Brown v. Board of Education, of course, decided on May 17th, 1954. There is Sister Linda Brown and her father. Other people say the civil rights movement began on December the 1st, 1955, with the Montgomery bus boycott. The point of this slide is to show you that it was faith leaders that began the movement. Linda Brown's father was the Reverend Oliver Brown, who was an associate minister at St. Mark AME Church in Topeka, Kansas. Rosa Parks, on the opposite side of the screen there, Rosa Parks was a stewardess at St. Paul AME Church in Montgomery, Alabama. And of course, the young 26-year-old Martin Luther King Jr. comes to town as the pastor of Dexter Avenue Baptist Church and starts advocating the liberation theology that I spoke about in the previous slide, equality for all. But the movement began with faith leaders is the point I want to underscore. Next slide, please. Now, why? The question must be, why would faith leaders suffer, and why would they put themselves in a position to suffer? The answer is because from a theological perspective, suffering was redemptive. Isaiah 53 in the Old Testament, often called the suffering servant song, provides a core theology that undergirded the civil rights movement and the fight for voting rights. Dr. King said that suffering was redemptive. Now, I'm unpacking here only verses 5 and 6 for you in the interest of time. I just want to briefly read verses 5 and 6 from Isaiah 53. They provide, but he was wounded for our transgressions, crushed for our iniquities. Upon him was the punishment that made us whole, and by his bruises we are healed. This is Old Testament. Some people say this is a messianic scripture in foretelling the Christ who would come, obviously the person of Jesus, and would suffer for all of humanity. Others say this is a theological belief that undergirds the fact suffering is redemptive when you're suffering for others or you're suffering for a greater cause. This is a theology that led and motivated the ministers and the faith communities in wanting to provide access for all in the civil rights movement. And it's what ushered in the Voting Rights Act as we talk about citizen participation in government. Next slide, please. Now, why would faith leaders get involved? When we talk from a Christian perspective, we're talking about Dr. King and those, again, that began the civil rights movement, whether you say it was the Rosa Parks crew or whether you say it was the Brown v. Board crew, they were Christian ministers and engaged in Christian advocacy. The image on the right, I want to unpack very briefly for you, and I want to reference a quote from Dr. King's first book, Stride Toward Freedom, the Montgomery story, written in the aftermath of the Montgomery bus boycott. The cross has two planes. The Christian cross has two planes. If you look at the vertical plane, up and down, the north-south axis, it is supposed to represent humanity's salvific relationship with God, right? So the Christian cross, or the cross, is about salvation. The role of the church is to save people. But the role of the church also on the horizontal plane means that we are equal to one another and we should be treated equally. In other words, some in Christian communities believe that we should only deal with life in the kingdom to come, but others say we've got to deal with social inequities and social injustices in the kingdom at hand. So there's the great dichotomy. Dr. King wrote about that again in his first book, the vertical part of the cross representing salvation, the horizontal part representing social relationships, and he argued the church has got to deal with both. Social inequities in the kingdom at hand, as well as salvation in the kingdom to come. So this is a philosophy that motivates people to be involved in civil rights and social justice. Next slide, please. What does that look like when it manifests? It looks like, in a chronological fashion, it looks like students doing sit-ins in the 1960s because they knew they were going to be beaten. They knew they were going to suffer. They knew they were putting themselves in harm's way, but a suffering servant theology says it's okay, it's for a greater cause. It looked like students, like freedom riders in 1961, again, putting themselves deliberately in harm's way, but it was not about them, it was about a greater cause. This is advocacy for opportunity for all. Next slide, please. It looked like moving down the continuum to 1964. I remind you, Andrew Young, an ordained minister, reflected in his book, his biography, An Easy Burden, reflected on the Civil Rights Acts of 1957 and 1960. And he says, the Civil Rights Act of 1964 simply wasn't enough. Though it was historic and important, it was insufficient without the guarantees of the ballot. So what do the guarantees of the ballot look like when you're talking about ministers? Next slide, please. It looked like John Lewis there on his knees on Bloody Sunday on March the 7th, 1965, a willingness to suffer for the greater cause. But again, there have been obstacles, but that suffering led to opportunity. There you see Martin King, obviously with his wife Coretta, casting a ballot in Alabama after passage of the Voting Rights Act of 1965. Obstacles and opportunities. Next slide, please. Whenever there's an action, there's always a reaction, right? I talked before about the period of redemption after all of the advancement of the Reconstruction era. So now, in response to the Civil Rights Movement success, especially the success of the Voting Rights Act of 1965, Richard Nixon engaged in a Southern strategy by using code words like law and order. Where have we heard those recently, right? Nixon engaged in a law and order campaign based on racial animus against blacks. So 1968 and 1972 presidential elections, he started using buzzwords like law and order, and he started to appeal to fear rather than hope. Nixon's strategy worked. This Southern strategy worked because at a core constituency, working class whites in the South, working class whites became a core component of the Republican Party. Now, at the same time, you fast forward a little bit on now the 1976 election, you've got Jimmy Carter in the White House. Jimmy Carter was an evangelical Christian. But at the same time, Jimmy Carter started to enforce civil rights laws, which said that if your institution is going to receive federal funding, it cannot discriminate based on race. Wait a minute. There was the Reverend Jerry Falwell, not the one that's in trouble now. This is senior. This is the father who was a leading televangelist, a conservative evangelical Christian who founded the Moral Majority to oppose mandated integration into Christian schools. The poster child of his advocacy was Bob Jones University in South Carolina. And because we need something to champion this, we're supposed to be moral, so we can't come out and say this is all about wanting to keep schools segregated. We need something that people can get behind. Roe v. Wade, we need to overturn that. Roe v. Wade was very, very much an afterthought. The real issue here that brought the moral majority together was their opposition to integration. Next slide, please. I'm reminding you that these are faith communities. So now what does this look like? It looks like in the 1980 presidential election, as Jimmy Carter was defeated, Ronald Reagan engaged in fusion politics. He made express what Nixon made implied. His fusion already had a solidified base of whites in the South. Now he deliberately courted white evangelical Christians, and there became a core constituency of the Republican Party. So what did this look like? This rebirth of conservatism, meaning getting rid of quote unquote governmental interference. Governmental interference often meant the protection of minorities or protection of those who were deemed to be in a protected class. Oftentimes you'll hear, well, let's just let the states decide that. That's not a federal issue. Let's let the states decide that. I want you to unpack for yourself and think about what that really means. We were focused on bringing the U.S. back to quote unquote moral values. Moral values oftentimes meant that the woman's place was in the home rather than taking a man's job in corporate America or in the government. So these were not folks who were advancing the women's rights agenda is the point I want to draw. These are folks who were much more concerned about the past than they were about charting a course for the future. And these groups came together. Again, this is fusion politics to form what we now know, by and large, in studying numbers and graphs and who's voting for who. This is the Republican Party, particularly across the South. Next slide, please. Here's the empirical evidence behind that. If you look over, this is a generation later, but if you look over at the poll numbers, the exit polls from the 2016 presidential race, again, my presentation here, I'm not so concerned about whether you vote Republican, whether you vote Democrat. I'm only talking about research and advocacy and how faith communities have been engaged in access to government, or access to the right to vote in particular. 81% of those who are part of that fusion that I talked about of what evangelical Christians are, 81% of them supported Donald Trump in 2016, and only 16% of evangelicals supported Hillary Clinton. My goodness. If you look at the slide on the, if you look at the graph on the right, 56% hardcore Republicans, 56% of evangelical voters readily identify as Republicans, with another 21% that are Republican leaning. In other words, the core issues that Jerry Falwell began with, that moral majority, have manifested in his courtship with Ronald Reagan, have really been solidified as a bedrock constituency of the Republican Party. Oftentimes, I'm not accusing anybody of being prejudiced, but oftentimes with fusion politics, you hold your nose and you vote for somebody maybe you don't agree with 100% because they're speaking to at least an issue that's important for you. All of that has been infused, if you will. Next slide, please. All of that has been infused in this generation with, if you look at the slide on the left, is this person still the evangelical candidate, right? If you think about what happened in Charlottesville, I'm not accusing anybody of being prejudiced, but when you're in bed with white supremacists, you've got to say things like, they're very fine people on both sides, right? But there is also, when you talk about faith communities, there are also those on the opposite side of the ledger that will continue to champion more liberal causes. And among them, I'm proud to identify there the Reverend Dr. William Barber. You see to his right, the Reverend Jesse Jackson is still on the forefront. The sign that Dr. Liz is holding there next to Reverend Barber says it all: fight poverty, not the poor. This is the religious community. These are religious or faith-based camps who are doing advocacy and access on behalf of those who need them the most. Next slide, please. Martin Luther King Jr.'s fourth and final book, again, asked the question. I'm talking rhetorically, but again, part of the goals that we identified earlier for this presentation, I'm skipping through hundreds of years of history very quickly to really 150 years of history at least, to really focus on some core questions, introspective questions I hope will hit you. Where do we go from here? So as we talk about the Voting Rights Act, what does the future of citizen participation look like after Shelby County v. Holder, after the Supreme Court's decision in 2013 to invalidate Section 4B of the Voting Rights Act while leaving Sections 2 and 5 on the table? The dog can still bite, but it has no teeth, right? So really, it's all proverbial. What does that look like? What does the future of citizen participation look like? I want you to think about the country that we love. What do race relations look like after the 2020 election? Breonna Taylor, Ahmaud Arbery, call the roll, so many names, George Floyd, call the roll of so many names in the responses we've received. What does the future of our country look like? What does the future of the court look like after Amy Coney Barrett is confirmed? She will be confirmed after she's confirmed to the Supreme Court. What does democracy look like? Next slide, please. I want to give just an overview of where we've been, and I think we have a few minutes then for questions and hopefully answers, right? As we think about the role of faith communities in advancing opportunity, as we think about the role of faith communities in creating obstacles to opportunity, again, the cross, as we talk about the civil rights movement and its leaders, has two planes. The vertical cross, the vertical axis of the cross, rather, vertical plane deals with salvation and the kingdom to come. And that's wonderful. And it's a whole lot of ministers that say the church should not be engaged in politics. We should only be talking about salvation. Martin Luther King Jr., however, said the cross also has a horizontal axis which means we must be engaged in social inequities. We must address those inequities because the cross is a horizontal plane, means we all are God's children, we all are equal. So faith-based communities have been involved in advocacy to create opportunity. In response to Jim Crow legislation, or excuse me, in response to the Jim Crow era, faith communities led the fight to give us what we now know as the Voting Rights Act. Faith communities has also been largely encamped, largely divided, if you will, between blue and red evangelicals identifying heavily with Republican voters and the more liberal faith communities, the Reverend Barbers of the world, the Reverend Jesse Jacksons of the world, the more liberal faith communities being on the left side of things, continuing to fight for, continuing the advocacy for opportunity. So the question becomes, what does the future of faith-based engagement look like? In all that we've seen over the last few years, particularly all that has been revealed in 2020. The proverbial question I pose to you, again, the title of Dr. King's last book, where do we go from here? Next slide, please. I am open. This concludes the formal part of my presentation. I think we still have a few minutes before we close up shop. Ms. Summer, I attempted, you told me we have a hard, fast stop time. I talked as fast as I could. All right, so there we go.
No, that was fantastic. You covered so much and gave us so much interesting information. Let me just take a look at the questions here to make sure I'm picking up some that we can cover. Okay, let's see. So one question is, so you remark on the clear and frankly unfortunate divide, I think, between liberal faith-based groups and what would be conservative, white evangelical faith-based groups. So I guess what I'd like to ask is, do you see any ground for reconciliation, if that's the right word, compromise, coming together, particularly in light of, Breonna Taylor, George Floyd, although, that clear problem and clear tragedy in our society being highlighted, and in light of COVID and the impact that it's having on all of us. It's not distinguishing between liberals and conservatives or whites or blacks, disproportionately impacting blacks, but we're all feeling it in some way. So I guess what I would ask is, do you see any ground for coming together?
So there is no way you could have known this possibly, but you have no idea how profound your question is. And the reason I laugh, do I see any ground toward it? The dissertation I just finished writing, that which is now being shopped for a book, is moving the church toward reconciliation. So yes, I do. I absolutely do. I have a book. I'm a name it and claim it. A book is coming out on this. What I see is, number one, the current occupant of the White House represents something, but he individually has been very, very polarizing. So in that regard, this bedrock constituency that has existed for 40 plus years, because of his personal conduct, there are opportunities to tear. And because of many of the horrific things that have happened in 2020, happened during this administration. The last night's presidential debate focused on so many children that have been put in cages at the US-Mexico border because of the inequities in the system, healthcare and otherwise, that have come to light because of COVID-19. I do believe people of faith will be moved with compassion and to do good. So fundamentally, that which unites us, I believe, is far greater than anything that can divide us. So I do believe that whenever there's tragedy, there's opportunity. And because there's been so much tragedy as of recent, with a conciliatory leader and someone that can bring us together and champion causes that are not about themselves, but about the greater good, I do believe faith communities can come together, but I believe more importantly, the country can come together. So absolutely, to your point, absolutely.
Thank you. That gives some room for hope. All right, well, we do have a couple of questions that we weren't able to get to. So I'm gonna send those to the panelists and ask you to address those and try to get answers back to the folks who had those questions. But let me just say to the panelists, thank you all for joining us today. and, you know, providing a lot of information in a short amount of time, and giving us, you know, some room for hope and areas of action, potential action that we may take in the future. But, you know, the votes around the corner, you know, election day is around the corner. Many people have already voted. So I guess I would just end by saying thank you all attendees for joining us. Thank you panelists, and get out there and exercise your right to vote. Thank you all.
Thank you.
Thank you.